The Let's Go Live button, which means we've got to wait for the stream to warm up. It's getting a little cold out here around these parts in Arizona. Cold for an Arizona boy. So, that means things have to thaw out before we can jump into the content of the day. Let's take a look over on YouTube for our secret, unlisted YouTube super secret dangerous cabal. We have, that looks like that's alive and well. Good, looking good over there. On Rumble, I think things are rocking and rolling. Got user 1121. We've got free Appalachian over there chatting away. Shout out to my Rumble friends. Looks like Twitch is online, so shout out to all my Twitch friends. And Twitter, Odyssey, and Facebook, which means it looks like we can go ahead and get started, which means they're warm. The tubes of the internet are warm. So let's go ahead and jump into it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Grueller. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We've got judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. And we're grateful that you are here and with us today, because we've got a lot to get into. In this episode of Watching the Watchers, it's Kyle Rittenhouse Trial Day 3. We're going to be going through it pretty extensively. I know sometimes people get a little bit tired of the deep dives, but this is a very important trial. We've got 2 weeks of this, so a lot of the political stuff we're going to get back to, but we could all use a break from it anyways. In the Rittenhouse case, we're going to be hearing from one YouTuber, somebody who did a lot of live streaming on the actual night back in August 2020, somebody by the name of Koerri Elijah Washington. And he started to testify in day 2 of the trial, and then things ran out of time, and so they carried it over into day 3. And so we're going to pick back up with him. He testified a good portion of the morning, slight cross-examination from Koerri Elijah, and then that wraps up his testimony. We're also going to revisit something that happened in day 2. Apparently, there was an FBI agent who testified on day 2, and they didn't air the feed for anonymity purposes, but there was a drone apparently over the area in Kenosha, Washington. And so we're going to take a look at what the FBI drone captured, and we're going to have multiple interpretations of this when we get to the government's second witness today. This was Detective Martin Howard, came out in court today. A lot of video exhibits got admitted into evidence, a lot, like 14 or 18 of them. A ton. And we're not going to go through all the different videos today, but we are going to just highlight certain exchanges that took place between the detective, Martin Howard, and between Elijah Washington. And so we want to make sure that we're giving sort of equal time to both sides. I'm going to try to limit some of the unnecessary comment today so we can make sure we get through a lot of clips and a lot of the questions, because yesterday there were just so many of them. And if you want to be a part of the show, we're recording this over at watchingthewatchers.locals.com, where there is a question form that we use so that you can ask some, substantive questions and don't have to pay a fee. If you're a supporter over there, you just get access to the form. We don't pay per question, right, like you do on YouTube or on Rumble or some of those other places. So it's very convenient. Does help if you keep the questions in order. Of course, we only have one segment today because we are going deep on Rittenhouse. If you're looking for clips, we are going to clip up this show into the various sections. So it will be the Elijah Washington testimony. It will be the cross-examination testimony. It will be the FBI air drone testimony. Those will all be split up over at Robert Grueller ESQ/clips or clips, which is our YouTube channel, which is growing nicely. Thank you for your support over there as well. All right, so without any further ado, let's jump right into it. Kyle Rittenhouse Trial Day 3. We heard from 2 witnesses today. Specifically, we're going to take a look at Koerri Elijah Washington. You can see this is the government's case in chief. It's still day 3, still early in the trial. Government Prosecutor Thomas Binger, you can see right here in the middle, still calling witnesses. And so today, in day 3, what we heard was Koerri Elijah Washington, this fellow right here. He's a live streamer, and he was actually there the same night that the same night all this went down. He was there. And then we're going to hear from Martin Howard. He was the Kenosha detective. Now today, we also hear a little bit about Gage Grosskreutz, because during a cross-examination by Mark Richards of Martin Howard, his name comes up in terms of a search warrants and accessing his phone. And so we'll get into all of that. But there was something interesting that happened yesterday. You see this new person who wasn't on the board yesterday on day 2. This FBI agent, somebody named Brandon Cramin, was called in as a witness yesterday. So you'll notice that yesterday on the show, on day 2 of our coverage, Dominic Black was the last person that we wrapped up the show with. But apparently they just cut the feed off of the trial, and they were calling other witnesses when the feed was off. So that was Brandon Cramin, the FBI agent. Didn't get much reporting about what he testified about, but presumably he was just somebody who could lay authentication for the aerial drone footage, so that they just can't say, well, we just got this footage off the internet. Who did it come from? How'd they get it? Who can authenticate it before they get it admitted as an exhibit? And so presumably that's what Brandon Cramin was called into court to do as the FBI agent. But apparently they also brought out Koerri Elijah Washington. You can see him here. And so we're going to hear from him. We're going to start off with him today. Most of the testimony, most of the trial, at least during the government's case, was done by Thomas Binger. So we hear a little bit from the assistant prosecutor, James Cross, who, as I've been saying, is the technical guy. And there was an exchange here that we're going to get into. I'm not sure how deep we're going to get into it today, because it is highly technical. But they were arguing about whether video footage could be played with the audio on or the audio off, because if video footage is played with the audio on, it's going to have some commentary in there. And what if somebody is running around calling Kyle Rittenhouse a militia person? Well, that might be, pejorative. That might be something that might be offensive to certain people. And so if the jurors are hearing that language, in addition to what they're seeing, they might have a negative connotation about Kyle Rittenhouse. So they're arguing all about this stuff, as whether it's hearsay or present sense exceptions to hearsay. And so it gets a little bit technical, but James Cross today was involved in those types of conversations. Kyle Rittenhouse, of course, didn't hear from him. Unlikely that we ever will. Mark Richards did a lot of the testimony today, a lot of the cross-examination, except for Washington. This is Corey Chiarafisi, who did the cross-examination of Washington today. And then we're actually going to hear from Judge Schroeder today. He was a little bit on a tear today. He had a special little segment comment for the media, not really happy with how he has been portrayed in the media, saying, I've been getting skewered over this other case, and I'm going to let the media know I'm not happy about their language that they're using about my performance. And so we'll hear from him. So we've got a lot to get to. Let's get into it. Before we do, one quick reminder about the charges. Here we're talking about first-degree reckless homicide. We've got intentional homicide, attempted intentional homicide, Gage Grosskreutz, wounded, still alive. We have a deceased Joseph Rosenbaum. This was the guy in the red shirt. So we're going to hear a lot about these people. So just want to make sure that you're sort of getting pinged with who we're talking about. Richard McGinnis, the reporter, don't really have a good picture of him. Some unknown person that we obviously don't have a picture of. Anthony Huber is deceased. And then Kyle Rittenhouse also had a weapons charge in addition to one of the curfew charges. So just don't forget about that curfew charge. It is a lesser charge, but it is going to come up. Okay, so once again, quick reminder that we are talking about these two fellas. So Koerri Washington, the YouTuber from yesterday, and Brandon Cramin, FBI agent from yesterday. They had a sort of created this this composition of videos that are combined to show you a couple different things simultaneously. They're related to one another, so they're sort of they're matched in time. And so we can see two different angles of the same timeline. We can see one from on the ground, which is going to be over here on the right, and you can see the FBI drone footage up on the top. Now, this was assembled by somebody else, by a third party, and it's presumably been exchanged by the parties here, by the defense presumably received it from the prosecution at some point in the case when there was discovery being exchanged. But I want to just play it for us right now so that we can see some of these things that we're talking about. The detective, Martin Howard, is going to talk, of course, about the aerial footage. We're not going to hear from the FBI agent again. Detective Howard is going to be the person who's explaining the FBI video. And then we're also going to hear from Washington, who is the person who took this footage there on the right. So I'm going to play this. It's about a minute, I believe, and it's going to cut off before the shooting takes place. Okay, so just to make sure that we're not, violating any rules or anything like that, right? Nobody's going to be shot in this video. Here is what it looks like, just so we can see the juxtaposition of the two angles in the same timeline.
I see a large crowd over here smashing the SUVs. I think.
All right, now you heard the first gunshot, but we're going to learn as we go through this that that was not actually Kyle Rittenhouse's gunshot. And so this was, as you can see, looks like we got 4 different camera angles that are all being mashed together here. And the reason why I wanted to play this is because today was sort of a video show. Okay, here we have aerial footage up here in the top. We've got another, this looks like surveillance footage down here from a building looking onto the lot of the car dealership. Here's somebody on the street with phone footage. Another person here, Drew Hernandez. We've got his video footage. And so the point I want to make with this is that the prosecution, they are using both of these witnesses, both Koerri Washington and the detective, Martin Howard, to get all of these videos in, like a ton of them, 14, 15 of them. I have a super speeded up list of the exhibits that Prosecutor Binger actually submitted at the end of his presentation today. And it's a lot of video. And the reason he needs to do this is because there weren't any police there, right, who could go in and say, well, I was standing there and I saw exactly what happened. So he's got to prove his case using other witnesses and other evidence. Now, there's a common objection that's kind of going around right now from people saying, well, all of this should be excluded. All of this should just be, precluded and as not authenticated, or that these people are not expert witnesses. We'll get into more of that when we get into the detective. But by and large, it sounds like Rittenhouse's defense team is just letting this stuff come in. And there might be a reason for that, which I'm sure we'll explore as this continues to unfold. So this is what we're talking about. Today was testimony where we have 2 people talking a lot about videos, essentially. So you recorded this and you found somebody who had that on Twitter and you submitted that. A lot of videos. We're not going to talk about all the different videos. We are going to talk about the exchanges because most of us by this point have seen most of the videos, and it's not anything really different aside from the aerial footage, which we will spend some time on at the end of this entire show. So quick screenshot from the aerial footage, or from the composition that we just looked at. You can see over here the first shooter. This is Zeminski. This person is identified now. And when we did our original coverage of this back, a year ago, well over a year ago now, we made very clear note of that. We identified that gunshot in the audio profile before anybody else was hardly even talking about it. Now we know the person's name, and now that's sort of an additional component. As Rittenhouse was running away, not only from Rosenbaum, somebody else named Zeminski is back sort of behind him, shooting the gun off in the air. You can see that we're going to spend a lot of time on this in the last segment here, but Rosenbaum is here. He's the guy in the right, in the maroon shirt that we talked about. Zeminski's is the couple. They fired the gun off in the air, and this is Rittenhouse, and the government is going to say, so keep this theme in mind, the government is going to say that since the shooting took place this direction, sort of near where the car lot is, this direction to the left of the screen, that Rittenhouse was in fact actually chasing Rosenbaum. So see, Rittenhouse is to the right, Rosenbaum's to the left. They are both heading that direction. And so the government is telling us Rittenhouse was chasing Rosenbaum, and has been the understanding from our review of the law. It's not possible to sort of create a situation where you are the aggressor, and then when somebody responds to your provocations, that you get to suddenly invoke self-defense claims, right? If you go up to somebody in a bar and you smack them in the back of the head and they turn around and pop you in the jaw, and you strike them back or shoot them, and you say, well, that was self-defense because they were going to attack me. You started it. You hit them in the back of the head. You can't do that. You can't just smack them, and then when they are responding to you and you're in fear for your life, pull out a gun and shoot them. Now you're going to claim self. No, you can't do it because you provoked it. If he was going to hit you, right, you kind of probably deserved it because you started it. You were the provocateur. You were the person who was instigating the entire situation in the first place, which is exactly what the prosecution is trying to do here. And so we're going to hear from them when they do get to the detective, and we talk about this same theme happening, that Rittenhouse was this reckless lunatic out there that was really instigating the whole conversation. So with that in mind, with that idea that Rittenhouse is chasing Rosenbaum, with this idea that Rittenhouse was this lunatic with an AR-15 out there, let's jump into the testimony of the day. This is Koerri Elijah Washington. This is what this gentleman looks like. And so he was in court today. He is a live streamer and a YouTuber. And so he started testifying yesterday, and then he live streamed yesterday and says on his channel, Koerri Elijah says, I can't talk about it. Which is true. You can see this. He posted this 20 hours ago. Says, just saying, hey, but I can't speak about the thing, which is true. He really shouldn't be, talking too much about it in public. But here he is in court today, and they're asking him specifically sort of, tell us about the environment. What's happening when you are wandering around there in Kenosha? It's sort of madness. We heard yesterday from Dominic Black that it was like a war zone. A lot of people had AR-15s. Dangerous situation. Tell me what's going through your head. This is Thomas Binger asking Mr. Washington those questions.
At the moment this video was taken, on the night of Tuesday, August 25th, did you have any idea who Kyle Rittenhouse was?
No.
Had you even taken note of him at all that night, up until this point?
Briefly, kind of. I took a mental note. Just so when I arrived on the scene, I kind of looked at the people that were there and just took a note of the people that were around me, especially, people that are armed, to kind of gauge the crowd and, the environment that I was in. He just kind of looked young to me, and he had his gloves on and he was smoking cigarettes and stuff. So I kind of was like, he kind of seemed like an interesting figure, so I just took a mental note of that. It wasn't anything, I wouldn't say malicious. I just, a young person in a situation. Honestly, I would say it was mainly the gloves. I don't know why he had the gloves on. It kind of stood out. So I was like, all right, let me just kind of remember that, I suppose.
So I think you can understand that. The whole situation was kind of weird because it was a city being burnt to the ground. It wasn't good. So yeah, there was a lot of things that really stood out. And presumably somebody who is 17 years old, about to turn 18, running around with a assault rifle on a sling across his chest, looking at a picture right now, with a hat backwards, medic bag, running around with fire extinguishers and things with the gloves on. Yeah, it probably looks a little bit, strange, but not anything that would be, provocative or would be aggressive. He didn't use any of that language. He just kind of, mental notes, young gloves, cigarettes, seemed interesting, made a mental note of that. A lot of weird things happening that day. And so he's probably making a lot of mental notes about a lot of things. So not much came out of that, but here is where we now sort of get into his actual testimony about the stream. So this is a video of his stream, and we can see he's going to sort of walk us through it a little bit. This is now Binger asking him specifically, what did you do after those gunshots went off? So we're going to play this, and this is where his vantage point is from when the gunshots went off. So you can see sort of that he's looking in to exactly the area where Rosenbaum, as we're going to see, was chasing Kyle leftward on the screen. So back towards those lights in that direction. And this is where he was standing. So we're not going to see anybody get shot. We're going to hear the gunshots. And then Binger's going to ask Washington, what'd you do after that? After you heard the gunshots, what happened next? Here that is.
Oh, shit.
I'm going to represent to the jury. I don't think there's any dispute about this. We have just heard the shooting of Joseph Rosenbaum. And we'll go back and go over that in just a second. But Mr. Washington.
There was a first shot, which was not Mr. Rittenhouse's shot.
We'll get to it. Let me finish and I'll go back. Mr. Washington, after you heard the gunshots, what did you do personally?
I skated away to find safety.
Okay. And then eventually...
Yeah, skated away, right? Pretty obvious. So he wasn't really all that close to the scene, so we don't get much from him out of that. He's not really in a good position to tell us much about, was Kyle, running away in fear of his life or what was happening here. He was pretty far away, just heard it, and just as soon as those 4 gunshots went off, he takes off. Mark Richards, as you heard, he's like, whoa, hold on a minute now. And this is sort of the loosiness of the trial that I was mentioning, in the prior days that we've talked about it. It's just kind of loose, right? There wasn't a formal objection, there was no conversation about it. It's like, hey, by the way, when you're talking about this is we're not talking about the first shot. That first shot was all about somebody else. That was the Zemeckis family. It wasn't the shot that Rittenhouse fired. Those came after the first shot, right? Rittenhouse fired that second short succession of shots that actually ended up killing Rosenbaum. So very just kind of loose, and then the prosecutor turns around. Yeah, I know, Wolf. Don't worry about it. I'll get there. And you're going, what is happening? And so we're going to see a lot more of that as this continues to unfold, but just kind of, almost informal. And the judge just is very hands-off. So now that was Washington. And again, the government is not really getting much information out of these people because there's not much to get out of them. They were there. They were sort of, around the scene. They were just filming. Weren't really close to Kyle because it all happened so quickly. And there was only a handful of people there. This guy was not close to the actual shootings. He was somebody who just was standing there. And we don't know who else the government's going to call. But, presumably they've got some other people who are closer to this thing. They're not where that guy was. Otherwise, this guy just talked us through a bunch of video and didn't have much to say about Kyle other than, kind of looked weird and had the gloves on his hand. Not much came out of him that leads you to think that Kyle is a reckless murderer intent on, multiple homicides. So that was that. Now, the defense comes out. This is Chirafisi. And he comes out, and he's going to spend a quick minute on this curfew point. I know the curfew point seems very minor, but it sort of isn't, because what they're trying to do, at least mentally, is the prosecution is trying to show that sort of one domino leads into the other dominoes. Now, how this will settle out in the court of law, how all the law lays out in Kenosha, Wisconsin, I don't know. I don't practice law there. But here's what's trying to happen, mentally. The idea being that Rittenhouse had a sequence of illegal actions that all compounded that led into multiple homicide. Shouldn't have had the gun. We heard that testimony yesterday from Dominic Black. We've heard previously, and I don't think we played it from the prosecution, but Chirafisi's going to lay out their argument and then rebut it here, so you're going to get both sides of this. But Chirafisi then comes out and says, so let me back up. Rittenhouse shouldn't have had the gun, according to the prosecutor. This comes out, allegedly. This is the point they're trying to make from Dominic Black's testimony. Now, the prosecution is also trying to make the point and prove this count that Rittenhouse was in violation of the curfew order, and so he was sort of stacking multiple illegal violations, one on top of the other, which leads a person to say that they're in such violation of the law that they can no longer employ self-defense because they're sort of cracking the protection of that. So, whether that is legally accurate or not is a whole different conversation. We're hearing about how this is going to be settled, about jury instructions and what the judge allows in and allows out. It's a loose trial. And, a lot of this stuff, as we're going to see here in a minute, the judge is sort of dealing with on the fly. So, you can't escape those permutations or possibilities. Okay, so enough of that. Let's listen to Chirafisi talking about the curfew charge. Here he is.
So can I ask you, Mr. Washington, on the night of the 25th, when this all happened, the video that you just showed us, did you receive a curfew ticket?
No.
No? Okay. Were you aware there was a curfew in place?
Yes.
Okay. And you agree you were out past curfew, right?
Yeah.
Okay.
Okay, so you see what he's doing there. He's trying to minimize this thing. The government's going to come out, and they're going to try to stack those dominoes one after the other. Well, Rittenhouse shouldn't have even had that gun. His friend Dominic said so. And he was out in violation of the curfew. And then he was, being the aggressor. And so on, blah, 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 blah. So, okay, this big deal that they're making about this curfew violation. You knew it, right? You were out there. Nobody cared. Nobody stopped you. Did you get a ticket? No. Any of your friends get a ticket? Anybody care at all? No. So it's not a big deal, right? It was one of those things on the books. Nobody was enforcing it. Prosecution's going to be trying to make a mountain out of a molehill here, and he's going to try to minimize it, as he just did. A couple other questions here on this. This was something that I thought was symmetrical. So oftentimes what you'll see in trials is the prosecution will have a style. Yesterday we talked about this with Binger. Binger likes to come out and do the triad, right? And this is something very common in law, not something new here. But they come out and they do the thing, the one. Isn't it true that so-and-so and so-and-so and so-and-so? And you go, yeah, that's true. Wow, that sounded really true. 3 things. That's a really powerful statement. And so the prosecution did that yesterday. They came out and he said, well, there were a lot of people protesting. Wasn't there, Mr. Washington? But they were just protesting and they weren't shooting, were they? Right. And there were a lot of people shouting, but they weren't shooting either, were they? And there were a lot of people there with AR-15s and they weren't shooting either, were they? No, they weren't. No, they weren't. No, they weren't. Okay. So you get that sort of sequence. It's got a nice cadence to it, a nice rhythm. Kyle was a reckless lunatic because everybody else was protesting. Everybody else was out there shouting. Everybody else had guns, but he's the only one that shot anybody. And we heard a lot of that yesterday. Here is Chirafisi reversing that today.
Did you see anyone, to be fair, at that gas station chase anybody else trying to attack them? Did you see that?
No, not that I recall.
Did you see anybody on the ground and another person trying to kick him in the face? Did you see that?
Did I see another person try to kick someone in the face?
Yeah.
No. By the ultimate gas station, no.
Right. Did you see anybody hit somebody in the face or the neck area with a skateboard at that location?
At the location by the ultimate gas station, no.
See anybody chasing anybody, pointing a gun at them? See any of that? At the ultimate gas station?
At the ultimate gas station, no.
Okay. And
okay, so prosecution says Kyle Rittenhouse is a reckless lunatic because everybody else was able to not kill anybody, but he wasn't able to do that. So he's the odd one out. One of these things just doesn't belong here. Everybody else didn't kill anybody. Rittenhouse did. So he's the one who stands out. And what Chirafisi did is just said, not really, though, because if anybody else here had been chased, had been hit with a skateboard, had been getting, jump flying ninja kicked in the head, had been running from gunfire, well, they probably would have done the same thing, too. But that didn't happen to all of those other people who were protesting, who were shouting, who were out there with ARs. If that had happened to them, presumably more people would have done what Rittenhouse did, is what the defense is trying to glean there for us. And I think quite effective. So we've got a couple other things I want to just point out about Washington's testimony. Here is Chirafisi now going back through Washington's testimony, through some of the video, and specifically asking him about this. Did you see him being agitated? Did you see him acting inappropriately in any way? Here he is.
okay, does he, during this time that you saw him, does he appear to be agitated or irritated in any way to you?
Right there, it looks like he's just kind of standing, looking around.
Okay. If he would have been agitated or irritated or threatening in any way, would you have kind of followed him around probably, or no? with the camera to see what he was doing?
Like if he was threatening.
Yeah,
I
if he
mean,
was acting. I'll ask it to you this way: if he was acting inappropriate, would you have videotaped him?
if he was engaging with someone in an inappropriate way and it was in my radius and I caught it, then I would move to that direction. Yeah.
So, is it fair to say there's nothing about his behavior at the Ultimate gas station that made you focus on him at all?
At this point, I'm just kind of standing around seeing what's going on because there's not much happening. So yeah, there's no.
So just play it, please. So he's
All right, so there's some footage.
walking around like everybody else.
Yeah.
Is that fair?
Yeah.
Okay.
Right? Is that fair? He's just walking around like everybody else, not agitated at all, not upset about anything. And yeah, he says, yeah, kind of looks like it. Now, this was an interesting clip. Not really, not anything interesting here legally, but wanted to play this because I think this man, Washington, is insinuating that defense attorneys have small hands, which, is a personal insult, but that's okay. We'll let it stand. Here he is now getting into it about skateboards and about the trucks that are on the bottom of skateboards and about whether somebody would grab one of those trucks with their tiny lawyer hands and use it to smash somebody over the head. And so it's kind of a fun exchange because they're talking about something that feels like they're really battling over this thing about where to grab a skateboard. And it's not really consequential to this, but this is what happens oftentimes when you've got a lawyer who's trying to get a point out of somebody and somebody just doesn't want to give it to him. It has nothing to do with the case. It's inconsequential really one way or the other. The attorney's just trying to get him to say something and he just won't do it. And so it is pretty funny. Let's take a quick listen in and what's happening here. This is about a minute and a half, I think. So we'll just let it play.
You were asked how you got around that night, and you had mentioned that you had gotten around that night on a skateboard.
Yes.
Okay. Do you know what the trucks of a skateboard are?
Yes.
What are they?
They're what you attach the wheels of your skateboard to that attaches them to the board itself.
Okay. So can I ask you this? If you were going to swing that skateboard
Mm-hmm.
in an effort to create some velocity and hurt someone, how would you swing it?
If I was going to swing my skateboard to hurt someone,
You grab it.
I mean, I suppose it depends on the situation. It's a plank of wood pretty much, so however you favor holding a plank of wood.
Could you grab it? Could you grab it by the trucks and swing it?
You could you could hold it, and you could grab it by anything, really. Anything that's on it, you could hold it by. So yes.
But the trucks would let you swing it one-handed, right?
I mean, yes, I suppose, but again, you could hold just the board itself with one hand, depending on the size of your hands. Again, I have fairly large hands. I hold my board with one hand, all different types of ways. But if you have smaller hands, that would probably be the way that you would want to hold it if you were trying to strike someone, I suppose. I'm not an expert at striking people with my skateboard. I kind of just ride it like what it's meant for, so.
I'm just asking your opinion on it, that's all.
Okay.
Now,
All right. If, look, I don't need to hold it by the trucks, okay? I got pretty big hands. But if you need to hold it by the trucks, you little small-handed, tiny-handed defense lawyer, well, that's your prerogative, brother. I'm not an expert at striking people with skateboards, but... and so it has nothing to do with anything, right? But you could see he just did not want to answer that question. He's like, well, maybe. I mean, I guess you could strike him over the head with the trucks if you wanted to, but hilarious. Hilarious just from a human psychology perspective. Just people just don't want to cooperate, even on something that's so benign as to this. And it's just funny to watch him. His facial features, his expressions throughout the entire morning were quite hysterical. And he's got big hands, so he's got that going for him as well. Free Appalachian says, it's not the hands that matter. It's the feet, especially for European descendants, which I don't know if that's true or not. But all right, so we've got that going. Now, here is where Washington talks about somebody on this entire scene. Somebody was very unreasonable. Wonder who that could be. Here it is.
Just ask you this, and I don't know, you said that you kind of at least took mental note of
Yes.
Mr. Rittenhouse, maybe because of his age, because of the gloves, things like that, right?
Yeah, I mean, I took a mental note of some of people that kind of stood out to me, in my opinion. There's a lot of chatter on the internet and stuff like that. People are saying that people are going to like randomly kill people. Mainly they said they were going to be targeting black people or something like that, which is, you can all see I'm a black man. So took a note of that. So I was like, wanted to know who was around. I didn't necessarily feel like that was true, but you never know what may happen in situations that, clearly, who thought buildings would be set on fire and all of that. So you never know what really might happen. So I took a mental note of people that kind of stood out, like people that were acting erratic, like, I suppose, Mr. Rosenbaum, or the little things that stood out, like chain smoking with gloves on and stuff,
Okay. So can I ask you this? You described, if I have it right, you described Rosenbaum as acting erratic, right?
From all of the moments that I was around that you could notice, yes.
Okay. Other than smoking with gloves on, anything that Kyle Rittenhouse did that you noticed that was in any way erratic, threatening, use any term you want. Use any term that you want to describe. Anything that was out of the ordinary about his behavior.
The only thing I could say that was, I don't, and maybe it's, to be fair, like,
Come on.
this is just, I suppose, my opinion. He just seemed like he was young and like he didn't know exactly like what was going on. And because he was smoking so much, and again, if he didn't have the gloves on, maybe I wouldn't have noticed as much, but I just don't know why, like in the situation, why you would have gloves on. Maybe there's some technical reason or something that you may know, but to me, that's just what stood out to me.
Okay.
Not saying that I felt like, oh, this is a guy that's going to go around and mow a bunch of people down or anything like that. I just was like, oh, that's interesting. Let me take a note of that. And when he ran by, I was like, oh, I went in my Rolodex in my head, like, oh, I remember this guy from before. Is there anyone chasing him or anything? No. Maybe there's something happening down that way. So I just headed in that direction, not necessarily focusing on him.
Yeah, so you can see nothing there, right? Just kind of rambling on. No, nothing stood out. And it's hard to get him to give a solid answer, but he's not saying anything bad. It's not saying, well, he didn't do anything erratic, correct? No, correct. He's not getting any of those like hard ends where the testimony just ends with a mic drop, but the guy's just kind of rambling on. No, I mean, I didn't notice anything. Gloves, smoking. Okay, that's fine. The other guy, Rosenbaum, was being erratic, using his own words. This is the government's witness. They called him up. Rosenbaum, according to their witness, was acting erratic. And the defense just called them out on that. And so that was Elijah Washington. He's Koerri Elijah on YouTube. And so give him a follow if you're interested in seeing what he has to say about this. I'm sure that we'll be hearing more from him. Next up, in day 3 of the Rittenhouse trial, we've got Kenosha Police Department Detective Martin Howard. Now, we're going to start off with a brief intro from him about what he does. Basically, he was really scouring the internet right after they got news of the shooting. They heard it was a 4-homicide type of a case, and they just jumped right into internet research to go and start saving videos. Basically, what a lot of us were doing, saving videos and trying to analyze what happened and piecing together how the shooting unfolded. And so it's this gentleman here. This is Detective Martin Howard, Kenosha Police Department detective, been a detective for 3 years, was on patrol before then. And so right after this, he sort of is talking about curfew. He testifies about a lot of different things, but he was doing surveillance. And so he started really doing the deep dive into everything, search warrants, going and sort of, requesting documents and subpoenas and saving videos. And people were sending videos into Kenosha. Hey, I was there. I saw this. Where should I send this? It lands on his desk. He also had a partner, Ben Antar Marion, which I'm not sure if we're going to hear from him or not. but who interviewed some of the other individuals who were related to the case. And so let's start off by listening to what he says and about what his involvement is in the Rittenhouse shooting. This is Detective Martin Howard.
Now, did there come a time in that evening when your assignment changed?
Yes,
When approximately was that?
just before midnight.
And can you tell us more about that?
There was a report of a shooting in the area of 60th and 63rd in Sheridan. And at that time, we initially got a report that there were 4 homicide victims.
And that was a report you personally received?
Yes.
And as a result of that, did your assignment that evening change?
Yes, at approximately 12:30, Detective Vance Raymond and I were assigned to investigate this case.
And since that time, 12:30 a.m. on August 26th, the
Yep.
following morning, have you and Detective Antaramian been the primary lead detectives on this case?
Yes.
And can you tell us a little bit about what you have done personally in the course of that investigation?
One of the main things I did was go over the internet and try to find as many videos as I could of this incident. There were a lot of videos on social media, so I do Twitter searches for Kenosha and find videos that contain the incident and save those. There were also Facebook live streams like Mr. Washington's that we just saw. I was able to locate that and save that from Facebook. And there were several other locations that videos were found. Some private citizens came forward with video. We gathered those.
Now, you said that about 12:30 in the morning on the night of August.
All right, so that's it from him. Yeah, so he's just gobbling up data, right? Gathering every single piece of video surveillance footage that he can gather, watching everything. And so he wasn't recording these things. This is a little bit different than Washington. We just got done with Washington, and Washington testified earlier this morning in day 3, and he actually recorded the footage. He was there on the ground. And so you can ask him questions about that, right? If he says something in the video, if he's walking around and says, oh, that car is red, and we want to play his video in court, and he says that on the camera, we get to ask him questions about that. The defense can cross-examine him about it. It's called confrontation. You can confront him about his statements because he's in court. You said, Mr. Washington, that car was red, but it kind of looks like it's a maroon. Isn't that true? Well, no, I don't think so. It really is red. Here's what I think red is, and this is why it's red, not maroon. And you can have a conversation about it, but you get to confront that person. If that person is not in court and they're saying something on video, well, if it is something that might have an impact, if it's something that might be a statement, an opinion, something that might persuade somebody, or if it's labeling something as something, or if it's offering a perspective that maybe you wouldn't get from just watching the video, then now you have to talk about that. What is the impact of that? And can that come into court? Because if that does come in and that person who actually recorded that footage is not in court, you don't get to confront them about it. You can't cross-examine them. You can't have a conversation about it. You can't challenge their memory. And so this guy now is a detective who's just playing a bunch of videos today. And so I'm going to give you the full list of all the different exhibits that they go through. But we just heard him, my role in the investigation. I get on the internet, I download everything, I categorize it, I organize it, and I make sure that it's available for you. And so all of that went over to the prosecution, and it's in the list of like 15, 20 exhibits. I don't know how many, I didn't count them all, but he walks us through this all afternoon. I mean, it's like a full day of scrolling through videos. Most of these we've already seen. We're going to talk about a couple of them, but before we get into it, want to show you that this guy also had a conversation with Kyle Rittenhouse. And remember, Kyle, if you watch a lot of the footage that we've already watched here, he is sort of on the ground. Somebody is doing a flying ninja kick through the air. Somebody's swinging a skateboard his direction. He sort of was banged up a little bit. And so the prosecution, this is, again, the government's witness. They came out today and they asked this detective, can you tell us about Kyle's injuries? Because you met with him that very night, didn't you? How did he look? What kind of shape was he in? Here's the detective.
Have face-to-face contact with the defendant.
Yes.
Did the defendant indicate to you that he had suffered some injuries that night?
Yes.
Did you take photographs and document those injuries?
Yes.
Can you tell the jury about those injuries?
He had an approximately half-inch scratch above his left eyebrow. He had a small cut on the inside of his lower lip, slightly offset to the right. There is a approximately 2-inch scratch below his left collarbone. There was some redness to the right side of his belly button, just above his waistline. There was an approximate 2-inch scratch on his left forearm. There was some redness on his right forearm. There was some redness on the tip of his right thumb. And on his back, there was a scratch somewhere on his left side, about the where the left shoulder blade would be, in that approximate area. And also there were 2 bumps on the back of his head that was approximately here, so above the left ear. Both of those injuries on his head I could not get to turn up in the photograph because Mr. Rittenhouse has very thick hair. But with the gloved hand, I was able to feel it. And both of these bumps I would approximate to be the size of a penny. And the skin was slightly raised, and I was able to feel that with my hands.
So he actually had a whole laundry list of injuries. When I first was listening to this, I was thinking, is he reading off of notes or is he just memorizing this? You can see he's sort of looking at the jury, just walking through the list. This one, like a doctor. And he's just a big laundry list of all the different problems that he observed on Kyle Rittenhouse. Now, something like that might lead somebody to believe that maybe self-defense is appropriate if somebody is sort of on the receiving end of all of these different abrasions throughout their body, but not Prosecutor Binger. He just listens to that whole list, and his very next question to the detective is, that's the extent of his injuries. Is that all? That's it? Here he is.
Was that the extent of the injuries that the defendant reported to you?
Yes.
That's the extent. So, and you go, that's the extent? Yeah, that's a lot there. 2-inch scratch, left collarbone, redness right side of the belly button, waistline, 2-inch scratch, left forearm, redness right forearm, tip of the right thumb abrased, back left side injury. He pointed to that one. 2 bumps behind the left ear, kind of banged up a little bit, banged and bruised. Prosecutor's like, that's the extent of the injuries, right? Like he didn't get shot or like stabbed or anything, did he? No, that's it. Yeah, that's all that happened there. So, yeah, it kind of sounds like he was, in fact, assaulted. Now, here is what I was sort of foreshadowing. This came up as we continued to play the videos. As I mentioned, a lot of videos today. Probably too many videos, to be honest. But the defense didn't even care. They're just like, yeah, play whatever you want. Let it in. Who cares? Play it all you want. And the prosecution, for some reason, seems to think that these videos are, damning. I think that they're exonerating, if I can be honest about it, but they want all of these videos in, and they went through every single one of them one by one, like they have, a winning hand, like every single video is a jackpot, like, oh, boom, now what are you going to do? Now what are you going to do? Now what are you going to do? And so they just went through this. The defense just let it ride until we started to get to some commentary in the audio. They weren't really debating about what you see in the video. They don't care much about that because it's probably going to come in as evidence anyways. Once you kind of get one angle in, probably going to get a couple other angles in, depending on who you have. The government, may, in order to authenticate this, just may want to drag all these people in as witnesses, just like they did with Washington, right? They theoretically could have done this for all of the other witnesses, but they didn't. They didn't choose to do that. And so we don't know what the conversations were like between the defense and the prosecution. The defense at the start of this thing may have just said, yeah, play whatever you want. We don't care because it's a self-defense case and our evidence is clear as day. You can see exactly what happened. Our defense is not going to change. Play at 35 different angles if you want. Nobody cares. And you're going to see that was a strategy from day one, right? It's sort of, ultimate innocence. It's look at everything that we've got. And you're going to see that even at the early part of this case, when the investigation was still underway, Mark Richards and Kyle Rittenhouse gave the government access to his phone, everything. We're going to hear about that in our last segment during the cross-examination. But the point here is that all of this video was coming in. I know a lot of attorneys are upset about it. How'd they get that in? This guy can't authenticate anything, whatever. I can understand that perspective. It's a different style. If you're Ghislaine Maxwell's lawyer, that's your style. You are fighting to get every stinking shred of evidence thrown out of court. If you're Mark Richards, his style is let the jury see it all. If we hide it from them, if we try to fight over every nook and cranny in this case, well, maybe they are going to think that we're hiding something and we're disingenuous. That the alternative approach is 100% innocence, total self-defense. Look at whatever you want. We don't care. Make the government look like a bunch of fools for just playing this duplicative evidence, 14, 25 different videos, whatever it turns out to be, because all of them, and the only thing they do in every one of them is tend to show Kyle Rittenhouse is innocent. So play whatever you want. Now, that's a little bit of a riskier gamble, as we're about to see, but it is a strategy, and one that I don't think is all that terrible, honestly. So let's take a look now at the actual video. This is where we get into a problem with the audio. Again, the video is fine. Everybody can see what happened, but if somebody's on the video commenting saying, well, I think that guy's a murderer, right? You don't want that audio to come through to the jury, because obviously that's that person's opinion. It's not fact. Just like them saying, I think that car is red versus I think it's maroon. It's an opinion. It's testimonial. It's coming to a conclusion that hasn't been proven in court. And so if they're offering descriptions, you're going to hear the defense object to this. Let's listen how that sounds.
They're protecting a local car shop across the street. I saw yesterday, as this one, there's video of it on YouTube, of this one burn. And we identified people hitting it with bats and a whole bunch of other things.
I have objection to this audio being played and the editorialization. I don't have a problem with the video being played.
I think we've agreed to the authenticity of it. I think that the individual who recorded this is available to be subpoenaed if necessary.
No.
I don't think it's
No.
There's a rule of
No.
confrontation.
May we approach, Your Honor? I don't want to continue this to the jury.
Well, start there. Start from that position and we'll see. It's a confrontation issue.
May we approach, Your Honor? I'm sorry.
Ooh.
It's
No, because if it's be something that has to be a record, and I'll have to send the jury.
It's
on
not. I don't believe it's a confrontation issue, Your Honor, because we're going to be here. We've already heard audio from other witnesses, and we're going to hear more.
There was not an objection. I can tell you. If there's descriptive material, then he's entitled to confront the speaker.
There's not descriptive material of the defendant, Your Honor. This is not a confrontation issue.
You've heard it before?
Yeah, I've seen it in its editorialization.
He's already made statements, assertions of fact.
He just made one.
He did.
Okay, now, this is all happening in front of the jury right now.
Okay, we can play it without the audio. There will be times in which we will have audio of interactions with the defendant, where he makes statements.
Defendant's statements are admissible.
All right, I'll do my best to alert you when those occur.
All right, so they're going to get into that now. Now, all that took place in front of the jury. Now, the reason why you have motions in limine, the reasons why you have all of your pretrial motions, any of those issues typically should be resolved before the jury is sitting there listening to you argue about this stuff, right? That issue, presumably should have been resolved before trial ever started. Prosecutor should have filed something or had a conversation. I'm intending to play this whole thing. Defense could have objected to that evidence in its entirety. And so the defense could have been waiting to save that objection until it came right out in front of the jury, just to show them, look, this is not something that you should be listening to. So that might be good if the defense wanted to sort of show that the prosecution was trying to do something nefarious or underhanded, but the jury could also take a look at that and say, well, why can't we hear what that guy was saying? Is the defense trying to hide something from us? Maybe there was very valuable data in there, and now if you're a juror who's already leaning towards a conviction, now what do you say? You say, oh, the defense is trying to hide the ball from us. Why don't they want us to hear what's on that video? What did he say about it? right? So, you can see how that can split both ways. And so oftentimes what happens is both attorneys, they don't want to have those conversations in front of the jury, which is why it gets resolved via motions in limine. But this judge has been such a loosey-goosey operator that it's really hard to understand what's allowed in and what's not allowed in. And so it all just sort of takes place right in front of the jury. Now, the judge lets it goes on a little bit further until he finally excuses the jury and then gives us all a break because they're still continuing to hash this crap out over over the jury panel. All right, so let's listen in on the next clip. They're once again going to be fighting over the audio because this guy, the guy who's actually recording the video, who's not in court, government has not subpoenaed this guy to come in and actually be available to confront him. He uses the word militia members. He calls Kyle Rittenhouse some militia members. And that's not in evidence. Nobody's proven that yet. That's this guy's opinion. And he's not in court to cross-examine him about that. What do you mean militia members? Do you have evidence of that? What is that, like your prognostication? Do you just think because he's got an AR-15 that he's a member of a militia? Because he's wearing a hat or gloves or whatever you think is indicia of that that's enough? It's not sufficient. So don't label him something that might scare the jurors. Jurors might listen to that word and, oh, this guy thinks it's a militia members. Well, I'm scared of militia members. Conviction. Same thing that we were fighting over about the use of victims or the use of certain language that is just overly colorful. So watch and listen to this one, because as soon as he uses that phrase, Thomas Binger comes out and says, turn the volume down. Turn the volume down, because the judge just told him previously, I'm going to play it with the volume down, except when we're talking about the defendant's testimony. If Kyle Rittenhouse says something, we can listen to that, but not somebody else's opinion, right? It'd be the same thing if somebody else was walking around saying, gosh, I sure think Kyle Rittenhouse is a murderer, and I'm just watching him. Man, he is such a murderer. I can't believe he just executed those people out in cold blood. And you just let that testimony come in. It's his opinion. It's not relevant. And he's not there to be challenged on any of that. So here is how that sounded in court today.
Okay, cool. So are you guys? Do you guys mind? Is your way up on the roof?
Yeah, there is, but you gotta go through the shop, and we don't really want no one else going through.
Okay, no, that's fair. I thought I'd ask and make for some cool footage. But we got militia members.
Uh-oh.
Let's turn the sound off now, please. Thank you.
Yeah, turn the sound off. Yeah. Good call. Objection. Now, they don't object, right? They just kind of stay quiet. Listen, nothing happens, right? Just lets that ride for a minute. But that is a statement that is, a conclusion. It's not a fact and evidence yet, if it ever could be. And so here is where you'll see the judge gets frustrated with this and actually excuses the jury.
So they, loaded guns, so people take de-escalation. Yeah, it is a de-escalation.
Stop it. Here it is.
It's the same as the earlier objection. If he wants to play my client, that's fine, but this is editorialing.
I understand the objection. The problem is there are portions of this that don't have anything to do with the defendant that describe the scene, and I'm trying to give the jury
That's
a sense of the
hearsay.
scene.
It's hearsay.
I'm not introducing anyone's statements for the truth of the matter asserted. I'm introducing it for the state of mind of the defendant as he watches
If
this
it's
scene.
not for the truth of the matter asserted, it's irrelevant.
No, it goes to state of mind, Your Honor.
State of mind of
Of the defendant. When he sees...
someone else's. Would you do me a favor and step into the library?
Bye, jury. Bye. Because you shouldn't be arguing this stuff in front of them. So they blank out the audio, and actually,
Please don't talk about the case while you're out of the room.
Yeah, it tells them don't talk about the case. And that's all we get out of that one. So they actually end up arguing about it a little bit further. They take a break because the judge gets so stinking frustrated over the whole thing. And then they come back and we don't really have a ruling. Then they actually do play the video. So they play the video with the audio. And so we don't really know what the ruling is on it, right? And the judge is talking about curative instructions, whether he can just tell the jury to disregard all of these things. The Assistant Prosecutor Jim Krause was talking all about the exceptions to hearsay. So they're really trying to get this testimony in, and we'll see what the judge decides to do. They want the audio to be, in parallel And, you know, we don't know what the ruling is on this because you're going to hear now when I want to put a pin in this. We're going to get back to this. The judge does, in fact, admit all of these exhibits. And so my question is, all the exhibits with the audio or without the audio? Are we going to go case by case? Is the prosecutor now going to admit them with redacted audio, only the audio that is clipped that involves Kyle Rittenhouse's statements? I don't know. Right? That is something that I think would be very important for the defense to get their hands around. If the videos are going to be submitted, they need to make a decision about that. You know, what of that audio that is overly prejudicial can be allowed in or not. And from what I can tell, at least what we're going to hear about on the record, sounds like everything's going in. So I don't know. Now, quick pause on this. The judge ranted into the media today, unhappy about the characterization about how he's running this trial. Here is Judge Schrader kind of scolding him a little bit, saying, they're saying some crazy things about me on TV. Here he is.
Oh, I'm going to comment about the media again because there was a gentleman on TV night before last who said this is the most divisive case in the country today. So anything that undermines public confidence in what happens here is very important. It's important for this town. It's important for this country to have people have confidence in the result of this trial, whatever it is. And I don't care what it is. But people have to be confident.
Yeah.
There are people on the media, on reputable sites, that are saying things that are totally bizarre. And I'm going to cite one only because it is exemplary, and it stems from the conversation we had the other day about.
Okay, so he goes off into something, who knows what. But, you know, the point that he was making there, I think, stands. This is important, right? This is a reason why we're spending so much time on this trial. I've talked about this as being a case of clear self-defense that, you know, and I know that because I'm a criminal defense lawyer. I know when there are good criminal defense, self-defense cases and when there aren't. And I know that sometimes, you know, you get a little bit creative with self-defense. Sometimes it works, sometimes not. But when you get a really good one, it stands out. This one is about as obvious as they come from my perspective. Now, I am a defense lawyer, and so I am prejudiced that way, so bear that in mind. But we are going through this sort of one by one. Judge is getting frustrated with the media. We're going to see probably more of this as coverage continues. Right, trial is just getting warmed up. Judge, continue to brace for impact, especially with some of the issues that are coming up in the trial. So that's just getting started. Now, we go back. We sort of break for lunch in day 3, and they sort out this video stuff. So they're fighting over this. Judge scolds the media, goes back, talks about hearsay, a prior case that they had that he was ruling on. And I don't get the sense that a lot of people really understand even what they're talking about with all of these issues kind of commingled into each other. Hearsay exceptions, excited utterances, present sense impressions. The hearsay rules, just so everybody understands, they are convoluted as hell, right? You have hearsay, you have exceptions to hearsay, and then you have things that are actually hearsay, technically, but you just say that they're not. Why? Because the law just says so. They're just not. And you say, yeah, but that is hearsay. And they say, no, it isn't. And you say, yeah, it is. You just said it was. And they say, well, we're moving it into a different section of the rules of evidence. So it's not anymore. And you say, oh, okay, well, I guess if you say so. And so it sort of becomes very convoluted and confusing, and you watch it. If you're somebody who plays with these rules, you're watching all of these people try to fight it out. And you watch at one point, even the judge is sort of citing and referencing different parts of the law. And the prosecution, well, what did you just cite, Judge? And they cite it and they open it up, and he's like, well, that's in the sex crimes statutes there, Judge. That doesn't apply to anything that we're talking about. And Judge said, oh, yeah. Change the I's to A's, or the A should be the I. Okay, they flip the book. Okay, go to a different section. And so, like, a lot of this stuff is supposed to be fleshed out before trial starts, right? You work out all of these issues so you don't do this stuff in the middle of trial. They are. And you know, it's just a different way to do it. Okay, so we get back into the videos now, and the audio is here. So they're playing the audio. Of course, this is Kyle Rittenhouse having a conversation, but they were also playing a lot of the other audio throughout the remainder of the afternoon. Here, we're going to see Kyle Rittenhouse is having a conversation about having not having non-lethal, having this conversation about what is lethal, what is not having non-lethal. He's asking the detective about this, so we're still here in the prosecution's direct examination of Kyle Rittenhouse. This is Thomas Binger asking detective about it.
We're protecting from the citizens, and I just got pepper sprayed by a person in the crowd.
So you had non-lethal, but you didn't respond.
We don't have non-lethal.
So you guys are full on ready to defend the property.
Yes, we are. Now, if I can ask, can you guys step back? Medical. EMS right here. I'm an EMT.
Okay, so what...
Detective Howard, in that video we heard the defendant say that he does not have any non-lethal. Did you hear that?
Yes.
As a law enforcement officer, are you familiar with that term?
Yes.
What does that mean to you?
So as a police officer, there are various options that we could have as non-lethal force. Our presence is a non-lethal force. Our verbal commands are non-lethal. And there's also some physical things we can do as well. We can go hands-on. We can use different instruments like OC spray, it's pepper spray, and we also have a taser, and we have an aspeton. Police officers in the city of Kenosha carry all those things.
All right, so what he's saying is that Kyle Rittenhouse didn't have those things, right? Kyle Rittenhouse showed up with a gun. That's what the prosecutor's trying to get after here. He showed up with an AR-15 style weapon, and he was just out there to just kill people. He wasn't out there to solve any problems. He didn't have any non-lethals. He didn't have anything that this detective just laid out. Pepper spray, anything else that is sort of, non-deadly in his arsenal. All he had was a gun and a medical kit. So maybe he was really just out there for blood. It's kind of the theme, kind of the direction that the prosecutor is going for. Now, we also hear a breakdown of the shots. He's running us through the conversation about the 8 shots and specifically refreshing our memory about Joshua Zeminski. This is the person who had the gun up in the air at the very outset, right? He was the first gunshot that we hear when we get into the aerial drone footage in our last segment. He's talking specifically about this right here. This is the detective once again.
There were 8 shots that we just heard. The first one was Joshua Zeminski, correct?
Correct.
And can you tell the jury what he does with regard to that shot?
So Joshua Zeminski is, at this time, you could see it on the Reg Incognito video. At this time, he's walking slowly southbound on the West Sheridan Road sidewalk in front of CarSource. So Joshua's walking right at about this spot right here while the chase is going on in a southwest direction through the CarSource parking lot. At that time, Joshua Zeminski has a handgun in his right hand, and he raises his hand up in the air and fires 1 shot. At that time, Mr. Rittenhouse and Mr. Rosenbaum are running through the CarSource parking lot, so Mr. Zeminski's gunshot happens behind them.
Okay.
Shortly thereafter, the defendant fired.
All right, so once again, the government's witness said somebody else fired the first shot. It wasn't Kyle Rittenhouse, it was Zeminski, who was shortly around the corner right nearby. But that kind of opens the door to a lot of questions, doesn't it? Which we're going to get to during the cross. Now, this is where we're laying the foundation for the FBI aerial footage. And I want to make sure we save some time and spend a quick minute on this because it's very interesting. We have the same drone, the same aerial surveillance footage, 2 different interpretations. Let's take a quick look at how they're laying that foundation here.
I'd like to show exhibit number 9, which
this
is
the
aerial
detective
surveillance video from the FBI.
Now, we are going to see them zooming in. This is the corner where there's the car lot. And so let me swap onto my laser pointer here. We're going to watch this several times so you can see where my laser pointer is, there's this white dot running to the left side of the screen over here in the bottom right. See this running right here. And we're going to break down all of this. But this is the FBI aerial footage. They're playing this for the detective, and he's just sort of, you know, they're watching this. There's the...
We can pause there, please.
The chase and the
Can you now please
pause.
play exhibit number 26?
Now, this is where they're laying out their narrative. That there was a chase happening there. So they're going to play their own exhibit. That was the first FBI surveillance footage. And then they're going to sort of come back with their graphics. It was the raw video. And now we're going to see what the government or what the FBI prepared for them, showing them essentially Rittenhouse, as we see here. Before I play it, let me show you, let me give you a sort of a rough outline. It's going to be diagrammed pretty well. But Rittenhouse is chasing, the theory goes, Rosenbaum this direction. And that was the provocation, according to the government. So here is their video now of the FBI aerial footage.
Brian, can we go back to the beginning of that and then pause, please? I'm going to replay it. Yes, of that same video. Detective Howard, the video that we just watched here at the beginning of the video, let's keep it paused there for a second. There are two individuals identified. One has a circle around them with the label person of interest 1. The second has a square around them with a label of person of interest 2. Do you see that?
Yes.
Based on your investigation, your review of all of the other videos,
All right, so
who are those two individuals?
Person of interest 1 is Joseph Rosenbaum, and person of interest 2 is Kyle Rittenhouse.
2 Kyle Rittenhouse
Now,
right
can
here.
you please play the video again, Brian?
Okay, there's Rittenhouse, bottom right. Person 2, slow motion. Looks like he's coming on person 1, sort of. Person 1 comes out from behind this car. And we see the circle and the square come together right there. Person 2 is Rittenhouse, now is ahead of the circle, running back towards the building. The circle 1, Rosenbaum chases him until the drone zooms back out and everybody scatters.
Thank you.
Okay, so that's the narrative. That's the conversation. Rittenhouse was chasing Rosenbaum. That's the conversation that Detective Howard was sort of led through. And that evidence got submitted as an exhibit, and it was published, and it's going to be available for the jury to take a look at. And we saw sort of a changing of the square and the circle. Rittenhouse was the square, circle was back. Rittenhouse comes up to the circle. There's something that happens, and then Rittenhouse is running away, and the circle is following him until the shooting happens. And so the prosecution is trying to make the argument that Kyle Rittenhouse, the square, was chasing the circle first. He started it. He provoked the entire incident. And so then, as a provocateur, he doesn't get to shoot and kill somebody. He doesn't get to use self-defense as justification for homicide because he was the chaser. Rosenbaum was the chasee. That's what the prosecution tried to communicate today. Now, all of those exhibits came in together. This was during the direct examination of Detective Howard, and all of these got admitted into court today. Let's listen exactly how that sounded when Thomas Binger was making the motion today. And listen closely. I'm going to have this played at double speed just for the sake of time because there's so many videos. But he says, motion to admit. Any objections? No. No objections at all. Accepted. And then he says, I'd like to publish those to the jury. Ready to go. Let's listen in on how that happened today.
Your Honor, I have a number of exhibits that I've just used. I believe they are exhibits 1, the Drew Hernandez video 023, exhibit number 2, the Drew Hernandez video 029, exhibit number 4, the Zeminski after Rosenbaum shooting video, exhibit number 5, the BG on the scene video, exhibit number 6, the CJTV running video, exhibit number 8, the Elijah riot video, exhibit number 9 was just played, it has already been admitted to evidence, that is the FBI video, exhibit number 12, which is the Kyle Cook video, exhibit number 13, which is the Lakota Lichtwalt live stream, exhibit number 14, which is the Reg Incognito live stream, exhibit 15, Richie McGinnis at Rosenbaum's body, exhibit 16, Richie McGinnis Kyle interview, number 17, Richie McGinnis walking with Kyle, number 18, rundown live video, and number 19, the Drew Hernandez shooting video. I would move, also there is exhibit 24, which is a photo of Joseph Rosenbaum in a plastic bag, exhibit 25, an FBI video with markings annotated at normal speed, and then exhibit number 26, which is a second FBI video with markings, which shows the, it's a 5-second clip from second 23 to second 28. I would move all of those exhibits into evidence.
Whoa.
Builders, Your Honor.
Receive.
Boom. No objection and receive. So however many exhibits those were, I can't even remember. He just said it, but 20-something exhibits. A lot of them all submitted in front of the jury. They're going to be able to just scroll through them as exhibits, run through them, go through whatever they want, make their decision. Rewind, super slow-mo, freeze frame it. So you're going to be sort of if Rittenhouse is acquitted, kind of sounds like an obvious thing because it's so obvious. The evidence is so obvious that it looks like self-defense. But if not, if the jury comes out and convicts him, you're going to have a lot of defense attorneys saying, I cannot believe they just let all of that evidence fall right into the jury's lap without going through a more robust process, determining whether or not certain audio can come in or whether certain video should come in, or not requiring the government to meet their burden, right? Making sure that they subpoena everybody, and before they get any single video recorded in, that it's authenticated, that we have the witness there, the person who recorded it there for confrontation, for cross-examination. They just kind of didn't put up much of a fight there, putting all their eggs in the basket that the jury's going to look at all of this and just say, yeah, it's pretty clear to us. Looks like self-defense. So a little bit of a gamble there, but we'll see if it plays out for him. All right, and so that was Mark Richards, who was, that was Thomas Binger, who was doing a direct examination of Martin Howard, the detective. After Thomas Binger interviewed Detective Howard, it was time then for Mark Richards to come out for the cross-examination. This is day 3 of the Rittenhouse trial. Now Mark Richards is up. He's got the opportunity to go in and cross-examine the detective, and he starts off by laying out the foundation, the framework, talking about the idea that you investigated Rittenhouse, didn't you? Search warrants, you had checked his emails, you looked through all of his social media accounts, Facebook and TikTok and everything. You did that, didn't you? It's going to be important to understand that you did that, because I'm going to ask if you did that for other people associated with the case. People like Gage Grosskreutz specifically. Did you do that same investigation for him? And if you did anything happen during it? Let's take a look. Here's Mark Richards cross-examining the detective, asking him specifically about the scope of this investigation and the inquiry using search warrants and other types of retrieval methodologies. Here he is.
Now, you went and got a bunch of information in this case through documents. Is that a fair statement?
Yes.
You did multiple search warrants.
Yes.
You did multiple subpoenas for records, correct?
Correct.
And a lot of those search warrants were directed at my client's social media, correct?
Correct.
His telephone.
Correct.
I'm sure I'm going to miss some, but Instagram, TikTok, all of those.
Yes.
Multiple email addresses.
Yes, Google.
And Facebook.
Yes.
And that's so you can get as much background on the individual who is the suspect, correct?
Correct.
That's all done after that night.
Correct.
And that's not something you really have to worry about in the short term going away. You get the subpoenas to these computer companies, it's there, they provide it to you, you get it, correct?
Yeah, the first thing we'll typically do is send a preservation letter to preserve the records, and then a search warrant and subpoena. Those can come a little bit further.
Okay, so he talks through what the process looks like, sends a preservation letter. Hey, Facebook, I know you're not going to give it to us just because we asked, but don't at least destroy it. No, you've got some information. We're going to go and get a search warrant, so we're going to get a court order to get it. So you are going to give it to us. But until then, since we know you require that, just preserve it. Just don't destroy it, because we're going to come looking for it, and we're going to come in hot. So he walks us through the process. And Mark Richards helps communicate and explain to the jury, educate, that getting access to an iPhone is very difficult. In fact, the FBI says that they can't even do it. So when all of this went down, the FBI wanted to see what Kyle Rittenhouse had in his phone. And they started to look into it, and they started to tell Kenosha and the prosecutors over there, we're not going to be able to help you get into this puppy. It's an iPhone. It's like weapons-grade security, right? They had to, hire some Israeli company to hack into, I think, the San Bernardino shooters or whatever. Really difficult to get into these phones. So what did Kyle Rittenhouse and his defense team do about this? Well, they wanted to help. They're out there helping solve problems. Here is what Mark Richards was asking about today.
When you seized Mr. Rittenhouse's phone, you wanted to get in the phone, you immediately sent it to the FBI so that it could be opened or cracked, and they told you they couldn't do that, correct?
Correct.
And myself and Mr. Rittenhouse found out about that, correct?
Correct.
And we said, you want to get in his phone? We'll give you the code as long as we get a copy of whatever you take, correct?
Correct.
And those arrangements were made, and his phone was downloaded.
Correct.
So there's nothing hidden.
Yep, so there's nothing hidden. So he's setting that baseline, right? iPhones are really difficult to get into. You wanted to get into it, so you looked, as a detective, right? You're looking into all this stuff. You wanted access to it. You sent it to the FBI. FBI said, we can't get into that puppy. Mark Richards, his defense team, got notice of this, and they said, we'll just give you access to it. We'll give you the code. We'll give you the fingerprint. We'll give you the Face ID, whatever you need. We just want a copy of it. Well, that sounds pretty helpful. Doesn't sound like a lunatic murderer. Sounds like somebody who might want to be, useful and help the government investigate the case. Very helpful, very nice of him. But what about Gage Grosskreutz, one of the so-called victims in this case? Did you also want to investigate him? We're talking about self-defense. We're talking about a multiple homicide. We're talking about a shooting. Somebody is charged with murder here. So presumably you're not just going after one person. You're investigating all the relevant entities, aren't you? What happened when you went and looked for Gage Grosskreutz? What happened when you looked at his phone? How'd that go down? Here's the detective.
In this case, on September 23rd of 2020, you got a signed search warrant from Judge Wagner for Gage Grosskreitz's phone, correct?
Correct.
And that was in preparation for a meeting that was going to occur on September 24th between yourself, Gage Grosskreutz, his lawyer, and members from the district attorney's office, correct?
I believe that to be correct, but I was not able to attend that meeting.
Okay, who attended it?
Detective Antaramian, and I'm not sure who else.
Okay.
But
The meeting was in person?
yes.
Okay, so search warrant in one hand, correct?
Yes.
Yep.
Telephone of Mr. Grosskreutz, presumably in Mr. Grosskreitz's hand.
Yes.
And for some reason, that search warrant was never served on Mr. Grosskreutz and his phone taken, correct?
Correct.
So you have a video from Mr. Grosskreitz's phone, correct?
Correct.
But you don't have the download of his telephone, correct?
No.
And you wanted the download of his phone, correct?
Yes.
You wanted the information that was in that phone.
Yes.
You had a search warrant to get all the information in that phone.
Yes.
And yet you didn't execute it.
No, I did not.
Okay.
All right, so just to put a pause in this one, just to make sure we're crystal clear about the difference between these two people, we've got Kyle Rittenhouse. He was involved in a shooting. Gage Grosskreutz, also involved in a shooting. We've got two people who were there at the same time at the scene, one on one side of the firearm, one person on the other side. Government says, we are investigating this. We think a crime happened here. We want to make sure that we have evidence from everybody. We need access to both of your phones. Kyle Rittenhouse says, yeah, no problem at all. Not only will I give you everything on my any videos I have, I'll just give you access to the entire phone, the whole thing. You can make a copy of it. You can do an image, duplication of the entire hard drive, everything. You get access to it. We just want a copy. We just want it. There's nothing to hide there. Just want a copy of it. No problem. They do that. They go ahead and get that. Same detective, same case, same shooting. Presuming there's going to be a self-defense claim, you'd think would want the symmetrical data from the other side. They do. Detective does want it. He wants it very bad. In fact, he wants it so badly, he goes and issues a search warrant and gets it. Goes and submits a probable cause statement, an affidavit, types it up, says, I want Gage Grosskreitz's phone. Can I have it? A judge says, yes, you can. There's enough probable cause here. Here's a search warrant. All you have to do, if Gage Grosskreutz doesn't want to give it to you like Rittenhouse did, just go execute the search warrant. It's a court order. And you can just take it. All you need is the city attorney or the county attorney. You need the prosecutor. You need everybody to kind of sign off on it, that it's okay to go ahead and do that. Seems fair, doesn't it? It does, doesn't it? Unless you're a victim of a crime. Then you have all sorts of special rules to protect you. Here's what that sounds like.
Do you know why it wasn't executed?
Concerns with Marcy's Law?
Who had the concerns with Marcy's Law?
Several of us did. I did. Attorneys did.
When you say attorneys, you're talking about Attorney Binger, correct?
Correct.
Marcy's Law is the Victim Rights Amendment, correct?
Correct.
And have you ever not executed a search warrant because of Marcy's Law?
No.
Okay. This is the first time ever.
Yes.
Is it the last time ever?
I can't foresee the future. But
Since that date, September 24th of 2020 to today, have you ever not executed a signed search warrant by a judicial officer of Kenosha County because of some concern of Marcy's Law?
no.
Yeah.
Yeah, he says, yeah, you haven't, right? Because what happened was the prosecutor kind of got in there and said, don't go and get access to that. If you go get access to that, then we're going to have to disclose it. And so what he's saying is Marcy's Law is a victim's rights law, right? If you are the victim of a crime, this exists all over the place here in Arizona as well. We've got a victim's bill of rights. Even though a defendant hasn't been convicted yet, right? They are presumed innocent in this country. For some reason, we still have a bunch of victims' rights laws that are presuming that somebody is in fact guilty, even though they've never been adjudicated to that degree at all. So same concept here, right? Victims' rights, they get shielded. You can't there's all sorts of things. You got to be, kid gloves around the victims. And so that's what's happening here. He is the victim of a crime. Marcy's Law says that they have all sorts of confidentiality protections. Normally, nobody gives a crap about him. But in this case, Thomas Binger, first time ever, we have a signed search warrant from a judge executed by a lawful judicial officer determining there is probable cause in a written affidavit from a police officer. But city attorney Thomas Binger come out and they say, not gonna go get access to any of that stuff. Sorry about that. So they say, well, that's okay. We don't need it. And Gage Grosskreutz, can you just email us that video? Can you just send that over to us? Just email that over to us. But they don't actually get the same full copy that they got from Rittenhouse. So it's a nice little way to sort of, rub their faces in that in front of the jury. And Thomas Binger kind of let that happen. If I were a prosecutor, I think I might have objected to that entire line of questioning and just said, Judge, this is burden shifting, right? The law is meant to protect the victims. They have no right to get that data. It'd be sort of like commenting on the defense. If the prosecution came back out and said at any moment, well, Kyle Rittenhouse, he could have come up here and explained this, but he used his right to remain silent, and therefore you should find him guilty because he didn't come up here and talk to you about this stuff. If the prosecutor did that, boom, mistrial right away. And you can make a similar argument if you're a prosecutor saying, the victim doesn't have to disprove their innocence or something like that and make an argument. I don't think it ultimately would win because victim rights bills, I think, have a lot of problems in general, burden shifting. And so the defense would just say it's their burden to prove their case. Somehow that sort of gets flipped for many defendants in many parts of this country. But you get the gist of what's happening here. So he goes through. Government really wanted Grosskreuz's phone. They got a warrant and they still didn't execute it because some bureaucrat somewhere stopped it from happening. And so they actually go and we take a look at the aerial photo. This is, again, cross-examination, Mark Richards and the detective. And this is the photo that we're going to spend some time walking through. You can see here that we have a little bit of a same drone, obviously, but little different sort of notations here. So we're going to see a lot of different circles around the people in question. And so it's going to be really hard to see on your screen. And so let me just sort of use the pen tool here and diagram what's happening. So we've got a blue circle that we're going to see turns out to be Rosenbaum. The white circle, I believe, is going to be Rittenhouse. And then we're going to have the Zeminskis here in the red and the green, sort of the Christmas colors. And so let's listen in as Mark Richards interprets this for us. And again, it's the same drone footage. two different interpretations, and you're going to see that one is sort of expanded a little bit in time. Let's take a look at what's happening here.
This blue circle.
Okay, so the blue circle he starts off with.
What I would say the second and third row of cars, Mr. Rosenbaum, correct?
Correct.
Blue is Rosenbaum.
This red is Mr. Zeminski, green Mrs.
Yes.
White,
Zeminski's.
Kyle.
Yes.
White is Kyle.
Richie McGinnis is to the left of the television screen, correct?
To the right.
In pink.
To the right of the television screen.
To the right. Sorry. Roll it, please.
Okay, McGinnis is over here in the right. We can see him. We can see that sort of all the parties are here. And so the drone is capturing a lot of the footage that we saw from on the ground. McGinnis over here on the far right. We've got Rittenhouse right here in the white. The Zeminskis who fired the gun down here in the bottom. And then you can see in the blue that Rosenbaum is sort of tucked away behind the cars. Now watch as this video plays with these notations. Okay, so stop it.
As Kyle, the white circle, comes to the Duramax, this individual, Mr. Rosenbaum, begins to come out of his hiding place.
Yes, he comes around the vehicle at that time.
And he's masked.
Yes.
And he comes around, roll.
Okay.
Stop.
Zeminski's.
Blue, again, Mr. Rosenbaum, correct?
Correct.
And now you begin with the chase. Mr. Rosenbaum of Kyle Rittenhouse, correct?
Correct.
Stop, not yet. Correct me if I'm wrong, but this looks like a classic ambush.
Objection.
I'm going to object as to the calling for the defendant's interpretation of things. The jury can make their own decision as to what the...
Sustained.
Okay. Mr.
Okay, so, kind of an obvious objection there. Sounds like he was ambushed. You call it, calling for speculation. It's asking for a conclusion. It's not an evidence. But the judge sustains that, and then we pick this up again with another question. Kind of sounds like maybe if it's not an ambush, is it something else? And listen to the language that Mark Richards gets this detective to use.
Rosenbaum is in hiding as my client arrives, correct?
It appears so, yes.
My client gets to this side of the Duramax, which would be the far side from Mr. Rosenbaum, correct?
Can you repeat that, please?
My client comes to the far side of the Duramax from Mr. Rosenbaum.
On the opposite
correct?
side of Mr. Rosenbaum, yes.
And his circle, my client is stationary, and his circle is closing on my client's circle, Mr. Rittenhouse, correct?
Correct.
And according...
Okay, so he is hiding. He's closing in on my client. You can see him coming around the car. He's got a mask on, right? All of these things. He says the word ambush. The jury heard the word ambush. The jury is going to be told the objection is sustained. Disregard the word ambush, right? It's not technically an ambush, but that's going to be sort of implanted in their brain, just like it is ours now. And what he's communicating to the jury is that when we see this down here, you see this blue circle. You see Kyle in the white. You saw Rosenbaum behind the car hiding. And then as soon as Kyle came around the corner behind the Zeminskis, Rosenbaum, the masked man who was attacking Rittenhouse, approaches him, jumps out of hiding, and follows Rittenhouse along the way.
This video, which we don't have sound because it's from 9,000 feet, this is right about the time where Kyle yells, "Friendly, friendly."
Friendly, friendly, friendly.
Yes.
Yes.
And it does not dissuade Mr. Rosenbaum, correct?
Correct.
Roll the tape. Stop. Kyle goes out into the road, goes back into the car sort of slot with him, meaning Mr. Rosenbaum, following, correct?
Correct.
All right. Again, Mr. Rosenbaum following. So we see, remember what we saw from the prosecutor. We saw the square chasing the circle, and then the circle chasing the square. Kyle was the provocateur. We see the same aerial drone footage, and it's reversed now. We see Rosenbaum running away, hiding in wait, lying in wait. The detective himself said he was hiding, said he had a mask on. Kyle comes running around the corner. The guy jumps out. What does Kyle say? Friendly, friendly. Did he say friendly, friendly? That's what the defense attorney said. No, he didn't. He said it 3 times. He said friendly, friendly, friendly. The witness corrects the defense attorney. No, he didn't say it twice. He said it 3 times. Friendly, friendly, friendly. And then what happens? Kyle jumps out into the street, runs back towards the building, and now the circle that is white is ahead of the circle that is blue because he's being chased. He wasn't the provocateur like the government said. He was somebody who was responding to somebody else lying in wait. And then that chased him after he yelled, friendly, friendly, friendly. He was trying to disengage from that person who was hiding, ambushing him. Ran to the building. What happened after that was self-defense. And so that, my friends, was day 3 of the Rittenhouse trial. We just finished talking about Mark Richards cross-examining Detective Howard, and it looks like we are going to pick back up on day 4 with more testimony from the detective. They didn't quite finish the cross-examination with him, and so we'll start up with him tomorrow. Trial is moving very quickly. Got a lot of evidence, a lot of exhibits admitted today without a lot of witness testimony. So we didn't get to hear from every single person who recorded all of those 20-something exhibits. All of those got admitted, and so we're going to be able to really fly through a lot of the evidence in this case since the jury can just look at whatever videos they want now. And so let's see what you have to say about this and more from our tremendous friends and our supporters over at watchingthewatchers.locals.com. See what you have to say about this. A lot of questions here. I can see them piling in. Thomas Binger says, Rob, please don't play the clip of me getting owned by Judge Schrader. Sorry, Thomas. It's too late for that. Already played a lot of them. We've got another one from Don MC in Ohio. Says, sent before the show started. Says, my wife is a criminal defense attorney and a recovered former prosecutor. Yeah, I hope she's recovering nicely. It's a lot of work. Here in Ohio, I'm a layperson. We watch these types of trials together. She has the opinion that the defense was way too lax today on objections or lack thereof. My question is, does it matter if it isn't relevant to their trial strategy? So it doesn't matter if they win. It matters if they lose. That's how these things work. So, certainly I can understand. Look, there are a couple different ways. If you had to plot all of defense attorneys on a spectrum, you're going to have these defense attorneys that are incredibly litigious. They're going to fight over every stinking syllable and article, a versus and, or the versus they, or, all the different words. Any different permutation of any argument, they're going to try to flesh that out and think about every variable and permutation and fight over everything. It's one way to do it. And sometimes that works, right? Sometimes you can get some evidence thrown out. Sometimes you make it so difficult for prosecutors because you've got 35 motions in limine, motions to suppress, right? This is kind of the Bobby Sternheim approach that we're seeing with Ghislaine Maxwell. She is fighting over everything. I mean, amazing stuff. If they send an email to her, she's like, you sent an email at an inappropriate time and I'm offended by it. And I found a statute that was written back in 1637 that says that you shouldn't do that and offend a nice person like me. And so then she, files 37 different emails and different motions about it and is just making it a mess. And so that's one approach. It works. It's used all the time. And that's not something that I disagree with at all. There's also another approach where other attorneys just sort of are reliant on persuasion. They're reliant on common sense arguments. They're reliant on just talking in plain English, right? Not killing each other over all the legalese, not killing each other over all of the motions in limine and hearsay rules and objections and rules of evidence and all blah, blah, blah. It's like, hey, we're going to go out there, we're going to communicate cleanly and clearly, and we're going to be persuasive, and we're just going to try to lay, sort of even our frequency match that with the juries. And I'll tell you, there's a lot of attorneys who are very successful with that approach as well. Now, I don't think that either one of the sides can sort of exist in a silo. I think that the most effective attorneys are going to be somewhere in the middle. I can see in this case why your wife says that. They have been very lax with a lot of these issues. I would not be comfortable personally if I were sitting there and they got to hear that my client was a militia member or something like that, right? I'd be like, oof. I think I'd be a little bit concerned that it's a little bit too lax. I think I agree with that, actually. way too lax. I'm not sure about way, like, how many, let's see how many Ys you have here. We have 1, 2, 3, 6 Ys in terms of way too laxed. I don't know if I'd go with 6, probably like 3. Let's say way too lax, not way too lax. Probably way, maybe 2, maybe, you know, I kind of like a more approachable style out of lawyers. You know, a lot of lawyers are very rigid, very formulaic, and it's off-putting to jurors, especially in a smaller town like this. Don MC in Ohio, shout out to your wife, criminal defense. Glad she's recovering from being a prosecutor. Thoughts and prayers with her. Says, Rob, former LEO says, maybe you should take a few weeks off, volunteer your talents for the team over at Rittenhouse. They're in desperate need of a video producer because of constant downtime while waiting for videos. They are destroying the continuity of the defense cross. Also a very big fan of easels and whiteboards. Trying to follow on IR video was difficult, probably confused the jury as much as the defense attorney. He could have mapped out the route that was taken along with the duration of Rittenhouse's escape from the mob. Then everybody would know what direction north and south are, including the defense attorney. Just keep it in front of the jury so they can refer to it as needed. The part that I did see was him leading the lead detective around by the nose while the detective helped him. I like my strategy better than the defense attorney. I didn't see all of the cross, but what I saw looked pretty good, just saying. That's a good thought, right? And that's former LEO, former law enforcement officer who is somebody who has a lot of familiarity with criminal law and criminal cases. I think very good comments there. Yeah, there's a lot of different ways you could do this, and I don't really know where the projector is or the camera is relative to the jury, and I don't know what they're leaving up there, right? I can't really see that. So I'd be curious to see, you know, how they're using that, just physically speaking. Boneless Ravioli is here, says, I know it was mentioned that the nature of Rosenbaum's hospital visit and the restraining order weren't going to be discussed in the trial, but isn't his restraining order and criminal history publicly available info? Yeah, probably. Also, wouldn't there be some mention in his criminal records that he has been seen by mental institutions? Yeah, so it would be, but the question is, you know, the jury shouldn't be going out there and doing their own investigative research, right? They're not supposed to be going and looking these people up or going onto Google and trying to investigate and dig deeper into any of these issues. All of that, you know, don't talk about the case, don't do any research, don't watch the news, don't look up any of that stuff. Just listen to what's happening here and make your decision accordingly. And so they shouldn't be looking up those records. But yeah, it should be publicly available. Trowpot says, watch the trial on Ricada's channel, says, what an S show from the defense. I saw him on Twitter say something like that. I'll have to watch that later and see what his perspective is on it. I think that he was objecting to the admission of any of the videos, which is, like, you know, it's somebody who's on a more litigious part of the spectrum. I think. I don't know. I shouldn't even say that because I don't know what he said. But if it's those sort of foundational questions, I can at least see the justification for why the defense didn't object to any of it. Just said, let it all come in, right? Because they're not arguing about the shooting that took place. Shooting took place. He was chased. He was running around all over the place. You can look at it 35 different ways from Sunday. Doesn't matter. Submit 200 different videos if you want to. He was acting out of self-defense. The shooting took place. It was totally justified. Yeah, juries watch it 400 times. And even the witnesses that are coming out in court, they're not changing the interpretation of any of the evidence, right? Washington came out and he's like, yeah, I mean, he looked weird. He had gloves on his hand, but, you know, so what? It's okay. He wasn't acting erratically. Rosenbaum was, but Rittenhouse wasn't. And, you know, in fact, he was out there, as we heard yesterday from Dominic Black, providing medical aid to other people. So it was like almost like, who cares about what the video looks like or about any of those, any of that evidence? And people, again, that all being said, it's about the narrative. It's about the testimonial nature of the commentary in the video. So if they've got 20-something videos and every single video is like, oh, these guys are murdering white supremacist militia neo-Nazis, that's a problem. But I don't know, you know, how that's going to be delineated because we've got a lot more trial ahead of us. That, I think, would be a problem. We have D. Delspa is here, says it's somewhat strange that in the contract to the Chauvin trial, all of this video evidence is just allowed without testimony for those who shot it. I suppose that's part of the reason why the defense was going on about something being admitted into evidence when it wasn't at the end of the day today. Yeah, Yes, but those videos were, gosh, I can't remember. How many of those videos did we get? I mean, several of those videos were body camera videos from the police department. So those could be authenticated by the police agency. They would just bring in the government expert to come authenticate those videos. And then those are, sort of formal records that get admitted. But I think the other videos that we got, didn't we get them actually testifying? I don't recall. Edon Tess says, Rittenhouse defense should have hired you, Robert Gruler ESQ, just based on what you put together last year. I feel like I am oriented on those videos because of your breakdown. You showed all the angles and the geography of the area. That was really helpful in understanding how this played out. Well, thank you, Edon Tess. Yeah, it seemed pretty obvious to me at the time. And we did do a very detailed breakdown. That was a fun sort of time for me, not because of the situation, which was obviously horrific and tragic, but I had no idea what I was doing on YouTube at the time. I was like, this case is crazy. I need to make a video about this. I don't know how to do it. I don't know how any of this stuff works, but we're just going to talk about it. And it turned out to be a good sort of decision, because it is a very interesting case, and I hope it turns out well. Three Girlies is here, says, is Binger trying to overwhelm the jury with all the video? Would this amount of video help the defense if it is not being slowed down for the jury to see? Seems like a stupid question, but can't Richard slow it down for the jury later on? It's from Three Girlies. It's another very good question, and you don't know. Yeah, I mean, it really could. It really could. What's happening here? One second here. I got a loud audio coming in from the other room. I don't know what that is. One second. Despite progress, joblessness continues to fall disproportionately on African Americans and Hispanics. The supply. Okay, so that was Jerome Powell in my office talking about something. I don't know why he just popped on. Some other video ended on YouTube, and then Jerome Powell was talking about the state of the economy, I guess. Okay, so back to Three Girlies. Three Girlies was helping us, talking about all of the video evidence and sort of being it being duplicative, it being overly cumulative. It's too much. The jury's going to get overwhelmed. They're going to go in there and they're going to play one video and another one and another one, and they're going to see it often and over and over and over again. One of the reasons why the defense may not want that to happen is because the jury is going to see Kyle Rittenhouse shooting and killing somebody multiple times, many times over. And that's not a good thing for most people to see. That's why you want to keep a lot of that stuff out of their hands so they don't get to scroll this back multiple times and watch shot, and see a 17-year-old kid shoot and kill multiple people. And so oftentimes you want to sort of limit that stuff. And if they get 14, 25 different opportunities to watch that from multiple different angles, it can be disturbing to a person's decision-making abilities, and it might cause them to be prejudiced against Rittenhouse, but we don't know. We'll see. It's all up to the jury. News Now, Wyoming says, have to admit, watching all the TV pundits respond to the hearsay argument has been hilarious. They can't justify the argument that the prosecutor was going with, that he was trying to show Rittenhouse's state of mind by showing what someone else was saying about what he was seeing, but that doesn't stop them from trying. There was no legal justification, but the pundits don't care about the law, only their feelings. Question about it, though. Do you think the prosecutor just wanted to get in the commentator repeating militia over and over again? Also, if the jury requests to view the video during deliberations, would someone have to go in and edit the video to remove all the talking except the Rittenhouse talking? And that was my question, News Now, right? That's sort of my problem with that. I agree with the objection that any commentary that's not a fact and evidence should be scrubbed from the final videos. It should only be Rittenhouse's testimony, stuff that is actually his state of mind, not other people's state of mind. And all of that can come in, but all of the external stuff should not come in. And I don't know what they decided, because during trial today, the judge, got irritated, called a break, And they came back and they played a lot of the video with a lot of the audio in it. So I don't really know what they decided, which is sort of par for the course with this trial. A lot of it isn't very clear. Monster One says AR-15 isn't an assault rifle, Rob. Well, that's not what they say on MSNBC. All right, Monster One, take it up with them. News Now Wyoming says, I have never heard a prosecutor testify as much as this guy does. Do you know who that person was? Answer from the witness, no. I'm going to represent that person was X. There was a lot of him representing what the evidence shows. And I think a lot of that, had to do with sort of the agreements that took place between the prosecution and the defense. It felt like there was a lot of that. Like the defense was just like, yeah, do whatever you want. Just get it in. It's fine. Don't care. We'll see if that works out for him. We have Three Girlie says, what is the benefit of bringing in Washington if he was not anywhere near what was going on? He seems like a useless witness because he wasn't next to any of the shootings. Is it only because he had video? Not really good video at that. Yeah, I think that's a fair assessment, Three Girlies. They needed somebody to come in and talk about the video. They had a video. It was continuous. It had some interaction with Kyle Rittenhouse, but he was not a great witness. Other than he was somebody else to talk about video, somebody else who was there. Soul Viking says, I skated away to find safety. This has to be the quote of the day. Yeah, I was sort of laughing at that. He kind of says it obviously. Well, what'd you do after somebody shot someone else there 30 yards from you? I skated away to safety, like a sane, rational human would. So it's an interesting question there from Binger. Let's see what else we've got. A couple more questions, a lot more. 503 says, the defense dropped the ball all day long, and the prosecutors got to have a field day. I'm in shock from the back half of today. I'm not even a lawyer. I was sitting there asking myself how much of the video it was relevant in any way. It's a good point. Yeah, it is a good point. As I said, right, you're going to see people split on this. Object to everything, fight, scrap for every single iota versus letting it in, dealing with it on the back end. Steve says, please don't use the term assault rifle or weapon. He had a semi-automatic weapon, that's all. Also, the witness did it. Use that term. Great show and analysis. Thank you. Is that a are we not supposed to use that word? I have an assault weapon right over there, as a matter of fact. So it's, it's perfectly, it's sunk in a boat. I forgot. It's not there anymore. It fell in that boat accident. I forgot about that. We have Drearier Spider says, you told the story of how you became a defense attorney on Viva Barnes' sidebar. Wasn't fully able to put myself in your shoes until this case. Binger is complete scum who is prosecuting a 17-year-old that he knows is innocent to advance his career and for political reasons. I wish malicious prosecution was a realistic possibility. It's from Drearier Spider. Yeah. Right, this guy, I told you about Binger, I try not to make these things personal, but this guy, you can just watch him and you just go, this guy, I can't believe you're even charging this case. But, he's a prosecutor, and he's that exact prosecutor type who you'd meet outside a courtroom and you'd say, hey, listen, man, this is not a justifiable case. You cannot bring this. And he'd say, oh, yeah? Well, my officer said so and so and so and so. And this, I've seen this before, Rob. This is your client, and you don't know what he's going to be like in 2 years. This is the start of something like this. He's going to be a monster. You take it easy, dork. Gosh. It's like hall monitors, these guys. It's the worst. All right, and this guy's worse than that. Yo Duh says, prosecutor led a cop witness over and over and over again. The defense just let them. So essentially the prosecutor was testifying, just letting the cop agree with him. That is true. Yeah, that's all true. No question about that. Totally true. My point here is that the defense doesn't even care. So the defense wasn't sort of making a mistake. This is part of the strategy. It's just let him talk about it all day. It's self-defense. Yeah, he shot him. He shot him, and he shot him quickly. But it wasn't reckless. And it wasn't murder. It was all self-defense. So it looks like the defense is rolling over, and it looks like they're laying down, but, maybe not. Nadler's Dirty Diaper is here, says, did I hear you cheering Chirafisi? I'm getting uncomfortable at 33 pounds now. Nadler's Diaper is just Getting more bloated by the day. We've got, let's see, Leafy Bug says, I've seen people noting that Kyle appears to have put on a fair bit of weight since his last public appearance. Weight gain, side effect of many well-known antidepressant meds. No idea if that explains the weight gain, but it did make me think about what Kyle has gone through and is going through. Taking the life of another, even in self-defense, would deeply traumatize any thinking and feeling person. Then the stint in jail, being subject to daily character assassination in the media fed by a zealous prosecutor, the ongoing threats to himself, his family, and now this trial hell. I hope Kyle has the strength to endure the burdens thrust upon him. That's from Leafy Bug in the house. Nice comment there, Leafy Bug. Some nice empathy for him. I always try to have that for anybody who's going through a situation like this, no matter who it is. Even Juicy Jussie Smollett, even Alec Baldwin, right? People going through the justice system are usually, in really hard positions. Some people themselves are broken and traumatized. Some people are put in the middle of, horrific tragedies like Kyle Rittenhouse. It is just a horrible thing. It's losses all around. So I appreciate you just sort of pausing, recognizing what this young guy is going through. It is hell. There's no question about that, right? I'm sure he does not want this upon him, his family. He's got a mother, a sister, a brother. It's a lot. News Now says, slight correction, the attorney questioning about beating with the skateboard was the defense assistant attorney. Yes, that's Chirafisi, right? Chirafisi is co-counsel on the defense, and he was also, yes, he is a defense attorney on Kyle's team. Biden baby says, Jill hasn't swung my plank of wood with high velocity in a long time. She says she boundaries unlike our country. Poor Joe. Maybe if Jill went and grabbed his skateboard trucks, things would be a little bit better in this country. One can only hope. C. Rose says, Washington helped the defense a lot with the Rosenbaum bomb. Did the state not prep their witnesses? I know, and it sort of feels like Binger sometimes will have these long pauses where he's like, I can't believe they just answered that way. That's not what I was going for. Three Girlie says, oh, how bad did Washington just mess up the prosecutor's case by saying Rosenbaum was acting erratic? It's like he just nailed something to the coffin of Binger's case. Yes, it was it was his witness. He called him. He knew what he was going to say. Leafy Bug says, Kyle was smoking while wearing gloves? Gosh, how damning. These prosecution witnesses sure are dynamite. Why are we putting Kyle through this again? It's because during an election year, he did something that I think was racist somehow. I think during an election year. Even though, if you look at our trial board and all the different people there, not a whole lot of black people or even non-white people. So I don't know how this whole thing was racist, but for some reason it is. Three Girlie says, could this detective actually believe that Kyle is innocent of all these charges? It is clear the detective understood that Kyle had been assaulted. I've been through shootings and riots before, so I've had to testify in court, and others I haven't. But things tend to cement in your brain like you wouldn't have in any other circumstance. He is reliving that night and what he saw on Kyle. It makes me believe this detective truly understands the circumstances that happened that night, and it sounds like he's not helping Binger out at all. I agree with you. And, part of this is a great point, Three Girlies, and I wanted to mention this, but what we did see with all of the videos, you have to remember that this also sort of takes a toll on Kyle Rittenhouse. He's sitting in court watching this multiple times, watching the shooting, watching the chase, watching the horror of that night 14, 21 times, however many times we watched it today in court. A lot. And he's sitting there having to relive this, shooting and killing somebody, shooting and injuring somebody, shooting and killing another person, being chased around this horrific scene. And Thomas Binger, this loser prosecutor, is just over and over and over again. Play it again, play it again, play it again, play it again. And so I can understand people saying that those defense attorneys should have just, enough already. You got what you needed in. What's your point? You got a video of the scene. You got their FBI surveillance footage. You got another one of Washington. Enough. You're done. You don't need any more of this. It's duplicative. It's overly cumulative. It's too much. We don't need it all. And if you have too much of it, it might be overly prejudicial to the jury. And it's cruel to the defendant to have them sit there. If you believe that Kyle Rittenhouse, as I do, acted out of self-defense, to watch him have to relive that same night over and over and over again. It's cruel as hell. But Thomas Binger doesn't care much about any of that, does he? Let's see. We've got some other questions here. We've got Speech Unleashed says, the judge should have blocked that video from being played to the jury, should have told them to dismiss what they heard from it so far. Those names describing Rittenhouse as militia and other things cannot be unheard by the jury. I agree with you, Speech. I would have freaked out about that. Objection, right there. And they did not do that, because he was probably going to object shortly thereafter, and he did. That was from Speech Unleashed. A couple more here. D. Delsby says, it seems like the jury process in this case is great, but the procedural process, electronic evidence, which is highly used in this case, evidence admission, is absolutely atrocious. I wish I would have spent more time on this process. Maybe you can talk about the difficulties of attorneys in courts these days. So the difficulties here, D. Delsby, is the judge. Honestly, the judge has been very loose in this case, very haphazard. We've talked about this, many times on this channel. Even at the start of jury selection, even when we were covering the pre-trial proceedings before jury selection started, at the very outset of this case, we were commenting on the fact that they were doing their Daubert hearings with the expert witnesses, and the judge sort of was in the middle of a Daubert hearing where they were examining the expert witness, and then just launched into a sort of a parallel conversation about a motion in limine about a similar issue involving expert witnesses. And I made this comment at the start of this case. It's very difficult to have clarity about what you can talk about if you don't do things in order. For example, if you have an expert witness, well, you're going to have to know what types of questions to ask that expert. If you don't have an expert, well, you don't have to talk about what type of questions to ask an expert. And so this judge is like, well, I want to know what questions you want to ask an expert. You say, well, we want these questions, but I also want to know, do we need an expert? And who is the expert? So, well, it's this person. So we examine them, but then the judge goes back to the questions you want. So it's this topsy-turvy world. It is, in my opinion, it is, basically atrocious. You run into these problems when a judge thinks that they can just deal with everything on the fly. You don't have any clarity, and that's why you have a prosecutor like Binger. To his defense, right? He came out and he started to play evidence, videos that he probably thought was perfectly legitimate, because this judge at some point in this convoluted pretrial proceeding process might have said, I'm open to it. Like, I'm open to hearing that. He might have said, well, let's see what happens. And then the objection happens in the middle of the trial, right in front of the jury, and the judge has to deal with it then, and he makes the right ruling then, but it makes the case very cumbersome. And we have to deal with all these issues in the middle of the trial. It goes fast. It makes everything, go relatively quickly. But, honestly, I think it opens up a lot of room for appeal. I don't think it's the right way to handle a courtroom, but it's not my courtroom, and he's been doing it for, 200 years, it looks like. John Halgren says, speaking about the judge addressing the media, even if the media is wrong, they have that right. What line is there, if any, for the judge scolding the media from the bench? Seems like he should have left that sleeping dog alone. Yeah. Honestly, I think this judge was just trying to talk about anything else other than the hearsay rules, because he didn't really know anything about the hearsay rules. So he started to sort of pivot into the media tirade, and then took a break to go look at the hearsay rules, and then they talked about all this stuff offline, as they should have in the first place, and then resolved it some way, shape, or form, but we don't know what that looks like yet, other than the fact that they came out and actually played the videos. Good to see you, John. 3 Girly says, I worked these kind of environments for a long time. I made sure I had every non-lethal capability as redundancy. I carried OC, taser, etc. as security. The idea that he did not have any non-lethal capability, that's beyond me. But that is a personal choice and a preference. Saying that, Kyle not having non-lethal is irrelevant to the case. He was being threatened with firearms and with a skateboard to his head. Those are both causes to use deadly force should it be available. I think this prosecutor is an idiot. Some 3 Girlies. It's a very astute observation. Yeah, he seems like one of those. Nadarb says, no, we're not running behind, Nadarb. We got this. So skip this if you're running behind. I don't know who made me more mad today, the prosecutor or the defense. The problem is the defense can be held accountable for malpractice, but the state lawyer risks absolutely nothing. Can lie, cheat, tip the scale. There is nothing people can do about it. This has to be changed to make state lawyers put more than a raise on the line for what they say. Disbarment and jail time should be mandatory with the trust we put in them. That's Nadarb. You know, Nadarb, you're speaking my language. You know, I get really irritated about this. It is an asymmetry in how we practice law, especially as a defense lawyer. If I screw something up, somebody goes on Yelp or they go on Google or they file a bar complaint or they, you know, blow us up wherever they want to blow us up. That's fine. That's well and good. We do good work here. I stand by our team. I stand by our reputation. I believe in what we do. So I'm okay with all of that. I don't need to hide the ball. Go look me up on myazbar.org. Go look my name up, right? Bar complaints. I'm fine with that. I love accountability, love transparency. I believe in it thoroughly. And it applies to people like me, but not to government prosecutors. There is no Yelp page for them. There is no financial repercussions for them if they send somebody to prison unlawfully. They don't even really get in trouble about it, right? You can file a bar complaint. What does the state bar do? They say, oh, it's a prosecutor. Nobody likes prosecutors. Defendants are filing bar complaints against them all the time. So who cares? Dismiss, whatever. They've got no skin in the game. They don't care. They go to bed, fine. They wake up the next day. They do it all again. There is no repercussion for that. In fact, they are incentivized the opposite direction. They get promoted. They get raises. They get made bureau chiefs. I actually, at one point, I had this grand vision. I think I still own this domain name. I actually bought prosecutorwatch.org. I think I bought that. I might do something with that someday. But they even criminalize that. Like if you know, anyways, Leafy Bug says, sometimes the judge's interaction with Binger remind me of an indecisive parent trying to deal with an argumentative child. How about a hard no? And because I say so, if he wants to know why. Yeah, Binger's not having a good time interacting with this judge, no doubt. Kincaid says, Rob, I like the strategy for the case so far. Facts are leaning for the defense. Even the judge's interactions, being unsure, has favored Kyle's side. Thank goodness he seems so far to be honorable. The defense can change tack for OS moments and let the prosecution walk into the judge's procedural quagmires. Maybe Kyle's team knows this judge's demeanor. I thought of the judge for Floyd's case was very well-spoken, technical, however, seemingly biased in courtroom practice. What say you? I agree with that. I like Judge Cahill a lot, but I thought he had a political bend, slightly, in court. Like, I think that, more evidence should have been admitted that was highly relevant to the case. But he made some rulings against Chauvin, no doubt. Marcy's Law, he says, for an adult who fired a weapon in a crowd, potentially instigating the events that caused a death, what the F? Could I send you an email asking some questions about becoming a lawyer? Of course, Kincaid. Send it over. Send it over any which way. Email's probably best on that one. Geegum says, as a mother, if Kyle was my son, I would be so worried that the defense lawyer isn't objecting and fighting tooth and nail against the prosecutor, sneaking things in and breaking the rules to push his narrative. He allowed them access to Kyle's phone. What? Forget about being nice. I want them to defend my son as if his life depended on it. It's from Geegum. And, I understand that perspective, Geegum. This is a very common thing in law. And I'll never forget one of the first times I got fired as a lawyer. I won a hearing and I got fired for it. But they just didn't like my style. It was something like this. We went into this hearing. It was actually sort of a family law custody matter. Went into it. It was a Tucson court. Went in and the family wanted me to just destroy the other side. Just eliminate them, right? They didn't even really, after the fact I recognize this, almost didn't even really care about winning so much as they cared about just destroying the other side. The other side was a husband who they were making claims about alcoholism on our client, and it was this big battle that happened. Anyways, long story short, whole hearing goes forward, and I let everything come in. Everything. They were saying our client was an alcoholic and a drunk and a horrible mother and a lunatic and a race, all of it. The worst person. All of that, not even relevant at all to the underlying legal issue. Had nothing to do with anything. It was all about essentially jurisdiction. We were in the wrong court. And so everything that they wanted to argue about, okay, if you feel good about that, that's all fine and well and good. And so we come to the conclusion of the case. I said, all right, you get your stuff out of the way. Hope you feel better about that. And I made my argument, and the judge goes, yeah, exactly right. Mr. Gruller, you're exactly right. And so we're going to have to, move to dismiss this out of this court. And the defense attorney for the opposing counsel stood up for her side and just jumped out of her seat. Because they lost. It was a catastrophe for her. And so they freaked out. And we left the courtroom, and the family was like, wow, I can't believe we won that. But they were a little bit shook because all this stuff came out. And about 2 days later, they call our office. We got a different lawyer. Why? We won the case. Yeah, but we just kind of wanted to make a change. They didn't like the style. They wanted a battle, right? They wanted to draw blood more than they wanted to win. And so you can see a situation like that could be happening here, right? And a lot of the times there's a concept called iatrogenics. It's when the healer is the harmer. It's when you do more harm trying to help than you do by doing nothing. Sort of like when they would draw blood from people to heal. You go to your healer, you're sick, they cut your veins open, you bleed out. Oh, well, we thought we were going to try to help this person survive, and now he's dead now. Oh, we'll not do that again. The healer does more harm. A defense attorney trying to get in there and meddle with every stinking thing can maybe do a little bit more harm than if they just let the natural progression unfold. So I can see this Geegum as you wanting to get in there and see somebody fight. But that's not always how the law works. Sometimes you can fight over a bunch of stuff that's absolutely irrelevant. And there are better arguments to be made. Great question, though. All right, we have another one from Thunder7 says, if there was a mistrial, will they retry or just let it go? Really enjoying your analysis. I would think that they would have to just let it go because it's not a good case. Somebody says, never knew you could walk, Rob. First time I've seen your legs when you have to go into the other room. What'd you think? Yeah, what'd you think about it? Did you think I had actual pants on? I hope so, because I do. We have another one from, Tree Mendes says, if I recall correctly from your original Rittenhouse videos, I don't think McGinnis said anything about Kyle Chase and Rosenbaum. McGinnis is going to be the key witness to this whole mess, I think. I just hope he doesn't change his story. I agree with you, Tree Mendes. I don't think that he will, because a lot of his testimony is going to be documented and sort of memorialized in the probable cause statement and in all of his interviews. And the defense seemed to be pretty robust, pretty sure of the idea that he was going to testify a certain way. During Mark Richards' opening statement, he said, you're going to hear from McGinnis, who's going to come out here and say none of this is true. I'm Not Gas says, Rob, did you get a chance to take a look at the allegations made by Barnes over at Barnes? Viva and Barnes with defense self-sabotage. Some interesting allegations, not sure how much is actually egregious and how much is just sour grapes for no longer being on the team. I saw a little bit of that. I did see Barnes talking to Viva about this, something about him not being on the team anymore. I have no idea about any of that stuff, to be honest. This has changed hands so many times. I know that Lynn Wood was working on it for a period. John Pierce had some work on this. We have a number of different foundations and a number of different people working in it. I don't know. I think that my perspective on all of that is to just watch kind of what happens in court. I'm even really sort of irritated with some of the media personalities who were reporting on this. I was reading some article in the New York Times. The court is not letting a lot of people into the courtroom, and the court is not very transparent about what's happening behind the scenes. They're shutting off the camera. We didn't even see the FBI agent yesterday. All of their motions are not publicly available. I have a stack of motions here from the court that I got. I got these. Look, I requested these. I don't know. These came from the County of Kenosha, the circuit court. You can see that there. I got this whole stack of Rittenhouse documents that I got, some time ago. Didn't have a chance to make videos about it because I got sick in September. But these were all the motions to admit evidence and all this stuff, right? These are all of Rittenhouse's documents. I've read through all of them and been studying the case. But it was like a pain in the butt to get those. And it's not because of the court's fault. Like the clerk of the court, who was extremely helpful. She was very useful, but we have to send a check in, got to pay for it. Then they've got to, and you can't, Venmo them or something. You mail it in. They got to mail it back to you. It takes several weeks. And so even when it comes to some of these, more substantive motions, I can't make heads or tails about what the defense is actually doing, because in order to get the documents, it takes weeks. And so if they filed something this morning, I won't get it until the trial is over. Whereas in the Chauvin case, all of that stuff was publicly available. It's right on the internet. So my perspective when it comes to sort of the the outside of courtroom stuff, what the New York Times is saying about this, what any of these people are saying about it, I don't know. I don't know. There was some New York Times reporter who was in the courtroom today, and she was talking about, jurors and about how aghast they were at all the videos that they were seeing, covering their mouth. One man was crying and all of this stuff. I don't know what to believe because I'm not in there. I can't see it. And this is a New York Times reporter. The judge, the court is very, lacking in any transparency. So it's hard to make sense of heads or tails of any of it. I just want to focus on what's happening in the courtroom, play around with both sides of the analysis, and hope that Kyle gets the best outcome. I mean, that's where I'm going to keep my head here. And hopefully that makes sense. Speech Unleashed says, any opinion on Viva Barnes' video about Rittenhouse defense being sabotaged by his own lawyers? Yeah, I've not seen that. So I got to watch that. I don't see it, right? I mean, I don't see it today. Personally, I don't see anything that would lead me to believe that it's active sabotage. I don't know what that's about, but I can take a look at it. Rob's Racist Lamp says, I played that video so Rob can get up and show everyone that he has legs. Happy Halloween. Yeah, that's fun, which is going to be interesting because I'm going to clip that out when this premieres. And so you're going to have to, the premiere people probably not going to see any legs. Probably. Maybe I'll leave it in. I haven't decided. 503 says AR stands for Armalite, which is a company, not an assault rifle. Rifles don't assault, people do. Glad to be back, by the way. Missed the locals. Good to see you, 503. Thanks for being here. Yeah, I know it didn't stand for assault rifle. I just kind of like how that sounds, having a nice assault rifle. I don't think it's pejorative at all, but I can understand it. I guess it's meant to scare people. Oh, it's an assault rifle. Well, yeah, I mean, it's a rifle. It kills people or animals, or it's for shooting practice, or it's just to look nice sitting in a gun safe somewhere. Let's see what else. Alec Baldwin says Kyle's guilty. Obvious what he did was intentional. Take it from me. I've been down this road before. I'm the poster child for gun violence. A couple more. Yoda says it's the smoking glove versus the smoking gun. Talking about Kyle Rittenhouse's blue gloves. Lil John says shots, shots, shots. Another angle of the video. Lil John in the house. Getting the club riled up. We have Larry says, did someone explain to the jury what hearsay is and why it should be disregarded? I'm thinking about the time when the audio said the militia is here. Yeah, and we played that, Larry, earlier today. And the judge sort of started talking about it, but that's not what hearsay is not one of the things that you can communicate to jurors. You can't communicate it to lawyers, most lawyers. It's literally a difficult concept because it's so complicated. Hearsay, exceptions to hearsay, things that are hearsay, but we say they are not hearsay. Non-hearsay. So it's very confusing. So even if the judge said, let me give you a crash course on hearsay, the jurors would say, all I heard was militia. Don't know what you just said, Judge. I just heard militia. So that's where some of the problems can come in. News Now says, just to end the show, go Virginia and New Jersey for change. How is New Jersey doing? Where are we at on the New Jerseys? Hangs by a thread. Let's see. Projected winner. Well, who are they saying? Oh, Murphy. Projected winner, Murphy. Okay, well, Virginia still went to Youngkin, which is pretty cool. Shout out to Than204 over on Twitch who just joined us over there. Big election news. Yeah, they were melting down about that. A couple other questions on Rittenhouse before we wrap up for the day. Greg Marat says, Rob, if someone is using an illegal weapon for self-defense, do they still get charged for using an illegal weapon? Or does the charge become null because it was used in self-defense? It's a great question, Greg. And you're going to see that, probably be a very fact-based analysis. I don't think you're going to see sort of a hard line either way on that. It's going to be up to the prosecutor, right? So a prosecutor might theoretically charge somebody with a misconduct involving weapons charge or something like that. So I'm trying to think of a scenario where somebody would have an illegal weapon. And it's not necessarily an illegal weapon. It's more of the idea that you're a prohibited possessor, which I think is really what you're kind of asking about. An illegal weapon, it's hard for me to fathom, right? Because in Arizona, we have very free gun laws. So an illegal weapon might be a weapon that wasn't properly registered to somebody or something that was, stolen or something like that. Like that would make the weapon illegal. I think what you're asking about is a person that is a prohibited possessor. They don't have the right to possess a weapon and use a weapon. So in the United States, that would be somebody who's a felon. If you're a convicted felon, no right to possess a firearm unless you do a restoration of those rights and get that right back, which we can help you with in the state of Arizona if you need help. But it is in that situation, if they use that firearm, defended themselves, a prosecutor might take a look at this and come to a charging decision, right? A conclusion about, should I charge this person with homicide? Is this a Rittenhouse case where I should actually file murder charges against this person? If yes, yeah, they're also going to get hit with a misconduct involving weapons charge for being a prohibited possessor in possession of a weapon. But if they decide, this actually was a pretty clear case of self-defense, they're probably, depending on the prosecutor, going to consider that person to also be the victim of an assault, a victim of an intentional attempted homicide, which justifies their use of self-defense, which justifies the killing, which would make them the victim of a crime that was committed by the deceased. And in that case, they're not going to charge the victim of a crime with another crime, right? They're not going to sort of add insult to injury. That's how, if I were a prosecutor, I would sort of work my way through that logic. Hopefully that makes sense. So the answer, probably no for most prosecutors, but you certainly are going to find those. Thomas Binger would probably be the first guy to charge you. Jay He says, I remember watching your analysis of this last year. Really helped me understand everything that happened. Appreciate your breakdown, all the hard work you put in, especially for those of us who are not legally minded. Keep up the great work, brother. Well, thank you, Jay He. That's a nice comment. And I appreciate you being here. I'm having a lot of fun. It is a lot of work. I got to tell you, it really is. Going through the trial today, man, I remember how much work this was during Chauvin. But it's also super interesting. I'm feeling like I'm getting to ride, sort of shotgun in a trial, so it's fun. Monster One says, Rittenhouse got hit with an assault skateboard. That's true. By the trucks, unless you have big hands. If you're a small-handed defense attorney, though, then not. Monster One says, did you miss my first comment about self-defense? I don't know, Monster One. Send it again. If I skipped, I don't think I skipped over anything today, so send it again. Miss Lucky says, medical people wear blue gloves when dealing with any injury. From Miss Lucky in the house. And those were all great questions from watchingthewatchers.locals.com. Monster One, if you're out there and you want to resubmit that question, if you have it handy, we'll hang out for a few more minutes to see if that one comes in. Otherwise, let's get some shout outs around the communities. We've got Free Appalachian and Catman.nr over at Rumble. They're chatting away. I see Free Appalachian says, if Kyle is acquitted, will he prosecute black? I doubt that. Well, listen, Kyle could always be convicted on that charge, or he can be convicted on a curfew charge or something like that. Sometimes the jury might split the baby, separate the baby from the bathwater to some degree, convict Kyle on a couple of the smaller, lesser charges, just so that he gets something, but not on any of the higher charges. Three Girly says, whoever does Nadler's diaper, every time I see Nadler now, all I can think about is his dirty diaper. I know, me too. And he just kind of waddles around like he's just hauling that thing around every which way. Pretty gross visual, but it is true. And over in our secret YouTube unlisted Cabal chat, we've got Just Cows playing hooky. Ronnie Cole, K. Beaner's over there. Zulu Zaitis in the house says, if I got up with my pants down, they would be sufficiently intimidated, I reckon. Talking about those big hands. Good for you, Zulu. Way to be proud, my man. I appreciate that. I can respect that. Very admirable. And congratulations as well. So we've got all of those amazing questions came over from watchingthewatchers.locals.com, over from our secret unlisted YouTube chat, over on Rumble, over on Twitch. We're all over the place. And the show is going to premiere on YouTube as soon as we're done recording here. Going to make a couple quick edits, get that puppy uploaded and ready to go over there. So if you're looking for a late show, that will be there soon. I want to welcome some new people over to our watchingthewatchers.locals.com community. Big shout outs to G Nonsense is in the house, just signed up. Welcome, G Nonsense. Frap Bod is here as well. Welcome, Frap Bod. Glad that you're here. Flea J joined us for the year over on our locals communities. We've got Bad Guy 24. CC is in the house. Very clever name joined up. Mind Magician in the house. C Rose is here. I saw him in the chat today. Hyper Spectral. Aaron Caroline is joining up along with Dave 520. Donna B300 in the house, Roybot, Ronnie Cole, French Toast, the AI Guy, Martini Junkie, Just Cows, Cold Painter, many others over at watchingthewatchers.locals.com, which is our community. We'd really appreciate it if you joined us over there, because we have our November monthly meetup coming up this Saturday. It's like in a couple days, 3 days. Saturday, November 6th, 7 to 8 p.m. Registration link will be up and over at watchingthewatchers.locals.com. If you want to join us, it is a very fun thing. We just hang out on Zoom for about an hour, hour and a half. Come with your camera on, turn it off, use your real name, use your fake name, doesn't matter. Hang out for 5 minutes, hang out for the entire time. But it's for all of our supporters, all of our community members at watchingthewatchers.locals.com. It's a lot of fun, very low key, very low energy. If you're looking for something fun to do on a Saturday night, that's when we're doing it. So 4 p.m. Arizona, 7 p.m. on the East Coast. I don't think that the time zone changes yet, right? That's the 6th. Time zone changes the 7th. So hopefully we don't screw anything up there. But come and join us there. And it's going to be a lot of fun. And that, my friends, is it for me for the day. Want to thank you so much for being a part of it. Reminder, we do record every day, 4 p.m. Arizona time, 7 p.m. on the East Coast, here at watchingthewatchers.locals.com. And then it is premiered on YouTube. If you want to be a part of the chat, make sure you stick around. It goes live as soon as it is done encoding on YouTube. And so be sure that you join us there. Otherwise, everybody have a tremendous evening. Sleep very well. We're going to be back here to do this all again tomorrow. Quick reminder on the show for tomorrow. We are going to have Rittenhouse coverage, but I don't know what time it's going to be because I have a big annual event that I have to be a part of. And it is all day Thursday, all day Friday. So the shows might be later. If the show is later, if it's like at 7 Arizona time, it will be live across the board, right? So we're not going to record it and then re-upload it. If it is later tomorrow, then we're just going to be live across the board, but it may not be at 4 p.m. It depends on when this event wraps up. And so I'm going to be juggling multiple things tomorrow, but the Rittenhouse coverage must go on. And so keep your eye out on that. I'll make sure that I keep everybody apprised of what my schedule looks like, but we'll do more Rittenhouse day 4 tomorrow, day 5 on Friday. Make sure you subscribe wherever you're watching this. I appreciate everybody being a part of the live show, a part of the recording. Sleep very well. Have a tremendous evening. I'll see you right back here tomorrow. Bye-bye.